The Appellate Division, First Department is now in session. Good afternoon and welcome to the Appellate Division, First Department's virtual oral argument. I will now call the calendar. People versus Bush.
Robert Caliendo appearing for defendant appellant Stephen Bush. Good afternoon.
5 minutes.
Diana Wang for the people, appearing for respondent. Good afternoon, Your Honors.
5 minutes. Wiltz versus New York State Division of Human Rights, submitted. Matter of R.C. Children, all 4 cases.
Kate Ferguson from the Neighborhood Defender Service of Harlem for the appellant Giovanni R.
You have 5 minutes and 1 for response.
Thank you.
Good afternoon, Your Honor. Cynthia Cow for the Administration for Children's Services.
You have 5 minutes.
Thank you.
Keenan versus Christie's.
Brian Isaac for the plaintiff appellant.
Okay, you have 5 and 2.
Thank you, Your Honor.
Glenn Kaminska for the respondent RCPI.
5 minutes.
Thank you, Your Honor.
Sophia Uvative for respondent Cushman and Wakefield.
5 minutes.
Gregory Warthall for respondent Christie's Inc.
5 minutes.
Thank you, Your Honor.
It's a lot of time for the respondents. Besson versus Doshi, submitted. Patmos Fifth versus Mazel Building.
Stephen Harfest for the appellant.
5 and 1.
Good afternoon, Your Honor. Andrew Hamilton from Blank Rome LLP for respondents. I respectfully request that my colleague Charles Fitzpatrick, a member of the Bar of the Commonwealth of Pennsylvania, be permitted to argue this appeal before the court on behalf of respondents.
Permission granted.
Thank you,
Yes, Your Honor.
You have 5 minutes. Barrero versus New York City Transit Authority, submitted. Bavers versus Shepard.
Good afternoon, Your Honor. Stephen Popovsky, Kleinberg, Kaplan, Wolf, and Cohn for appellants.
8 minutes.
Your Honor, may I have 2 minutes for rebuttal of the 8?
6 and 2.
Thank you.
Good afternoon, Your Honor. Craig Flanders from Blank Rome for the respondents.
8 minutes. People versus Murray.
Good afternoon, Abigail Everett for appellant.
5 and 2.
Thank you.
Good afternoon, Your Honor. Alexander Michaels for the people.
5 minutes. Tri-City versus New York City Taxi.
Good afternoon, Your Honor. Randall Smith for appellants Tri-City LLC and Indoor Car and Driver LLC. I'm here to introduce my colleague, Attorney Eric Shumsky of the Bar of the District of Columbia, and respectfully ask the court's permission for Attorney Shumsky to participate in this appeal and argue before the court.
That's granted. 6 minutes.
Your Honor, if I could reserve a minute of that for rebuttal, I would appreciate it.
5 and 1.
Thank you, Your Honor.
John Moore on behalf of the New York City Taxi and Limousine Commission.
5 minutes.
Thank you, Your Honor.
People versus Derek White.
Yes, good afternoon, Your Honor. John Vang for Derek White.
6 and 2.
And good afternoon, Vincent Revelisi for the respondent people.
6 minutes.
Thank you.
Awad versus Fordham University.
Good afternoon, Your Honor. James Ryan of Cullen and Dyckman LLP for appellant Fordham University.
5 minutes.
Afternoon, Your Honor. Alan Levine, the respondent.
5 minutes. Franco versus 1221 Avenue, submitted. People versus Wolf.
Good afternoon, Your Honor. Taylor Bonner for appellant, Mr. Wolf.
2 minutes.
Thank you.
Good afternoon, Claire Nielsen for the people.
2 minutes. Dong versus Cruz Marte, submitted. Vector Media versus Golden Touch.
William Gary for the appellant, Your Honor.
2 minutes.
Brian Katz for the respondent, Your Honors.
1 minute. Lee versus Lynn, submitted. People versus Vasquez, submitted. PV Holding versus AB Quality, submitted. Clark versus Empire General.
Good afternoon, Your Honor. Nicholas Herzler on behalf of Empire.
5 minutes.
Thank you, Your Honor. Lonnie Golansky for Rohan Clark, the plaintiff.
5 minutes.
Linda Stark on behalf of the third-party defendant, Lock Allen Masonry.
5 minutes.
Thank you, Your Honor.
Good afternoon, Your Honor. Christopher Summer for a respondent, Pen and Brush.
5 minutes. And the Article 87 proceeding, Savitovic versus Honorable Cooper, is submitted. I remind the attorneys to keep their microphones muted while they're not arguing until the case is called. And also I ask the attorneys not to speak over the justices. That's our usual rule, that's our traditional rule, made all the more important when we're doing the argument virtually. First case for argument, People versus Bush. Go ahead. Appellant on People versus Bush. Was that Mr. Caliendo?
I'm sorry, can you hear me now, Your Honor?
Now we can.
I apologize. My name is Robert Caliendo. I'm the attorney for defendant appellant Stephen Bush. I neglected to previously request 1 minute for a rebuttal time. May I make that application now?
4 and 1. Go ahead.
Thank you. I'd like to start with the prejudicial photo depicting a gun that was introduced into evidence. I think the people have already conceded that a generalized theory of access to guns or a gun that is not sufficiently similar is impermissible. And given that the people have already whittled down the test that far, is there any evidence of similarity between the gun in the photo and the gun actually used in this case? We don't know what the gun actually used in this case looks like, so there's no way to even make that.
Isn't the point of the photo and the fact that the defendant is seen with the gun to show that he had access to a weapon, and it happens to be that I think that's a small caliber weapon, and doesn't the evidence show that the weapon used was a small caliber weapon? But anyhow, but that he has access to the gun.
Well, I would sharply disagree with that. I believe the people have already conceded that a generalized theory of access to weapons is impermissible. The people, they will speak up if they disagree, but they have conceded that a general theory of access to weapons is no good. So the question then becomes, how similar is it in this case? The court just mentioned this concept of small caliber. We don't even have that. We don't know the caliber. We don't know if it was a small caliber like a .22 or a large caliber like a .357. We're left with simply this idea of quote unquote a small gun, which the people defined to mean anything that could fit in a sweatshirt pocket, not even a pants pocket.
Counselor, this is Judge Singh. Putting that issue aside, wouldn't it go to identity in this case?
No, because his general.
What was the defendant wearing in the photograph depicting the gun?
The sweatshirt in question, however, the defendant had already admitted to the police that he owned that sweatshirt and was wearing it earlier in the evening, and the police introduced a different, the DA introduced a different photo without anyone holding a gun, a much clearer photo of him wearing that same sweatshirt. So the picture with the gun did nothing to move the ball whatsoever as far as, was it his sweatshirt? Was he the man wearing the sweatshirt? He admitted he was wearing it earlier on the surveillance from 2 hours prior, and there was a different photo of him wearing the sweatshirt on a prior occasion. So it did nothing. It had no probative value on that score of identity. It was purely limited to this question of, is the gun sufficiently similar to the one used in the crime? I think if the people are allowed to define it down to just a small gun, and a gun, again, just a gun that could fit in a sweatshirt pocket, which isn't even that small. We're not talking about a side jacket pocket or a jeans pocket. You're talking about literally any handgun. And then you've defined it down to nothing. And it completely eviscerates the notion that there has to be some similarity.
Thank you, Mr. Calendo. People?
Good afternoon, Your Honors. Diana Wang for the people. May it please the court. With respect to the cell phone photo, as this court has said in People versus Alexander, there is no requirement of proof that the weapon in the photo is the actual weapon used in the crime. Rather, evidence is admissible so long as it tends to show that defendant had access to the type of crime used. Contrary to
So what is
defendant's...
this concession that appellant says you made?
We did not make that concession, Your Honor. The people never conceded that the photo only showed a general access to guns. Rather, the people said that this photo showed access to a small handgun that was used in the crime. And you can see from the surveillance video that we submitted to the court that it's a gun that is able to be tucked into a sweatshirt pocket, which is a small handgun, which is the type of crime, a weapon used in the crime. It's not a sword.
Counsel mentioned that, we're talking about a sweatshirt, not a particular kind of a jeans pocket or something like that. But the sweatshirt is a fairly sort of a big pouch. So any size weapon, if that's sort of the standard, that could be any size weapon, couldn't it? So really, this just doesn't go to any specific. I understand the caliber was a smaller caliber, but we really don't know what the gun in the picture was.
Your Honor, I believe that argument goes to the evidence's weight, not its admissibility. The type of weapon used here
that's to say that any picture of a person with a gun, any gun, is fine. Doesn't there have to be some similarity? Don't we have to be able to? I know we're not connecting the gun and saying it's the same gun. That's not what you're doing. But doesn't there have to be some more, specificity to it?
No, Your Honor, because the crime here is a shooting. It's a shooting, which means the weapon was a gun. And we know that the weapon is a small gun, not a rifle. It's not a long gun. It's not a medium gun.
You're saying any gun that's not any handgun is what you're saying. I'm quite clear this was a shooting, which means bullets.
Yes, it's sufficient to admit the evidence. We're not here at the stage of proving that it is the weapon used. We're simply showing that it is somewhat the type.
And so the question is, isn't that just so prejudicial that it sways the jury? That's really the question here.
For several reasons, Your Honor. First of all, any type of photo showing that defendant is in possession of a gun is prejudicial, but that's exactly what the evidence is tending to show, that he has access to the type of weapon used in a shooting, which is a gun. Second, there was a limiting instruction that was fashioned with the assistance of defense counsel, and the court gave that limiting instruction to the jury, saying it can only be used to consider identity. It cannot be used to consider propensity of violence or propensity to commit any of the crimes charged in this case. And specifically, it cannot be considered for the gun possession charges. And the jury is presumed to have followed that instruction. Here, we have no evidence on the record that the jury did not follow that jury instruction. In fact, we have the jury acquitting on the top charge of attempted murder. So if the photo was really so inflammatory as to have persuaded the jury would not have given a careful, considered verdict the way it did here. And finally, the prejudice was also reduced by the court to the extent it could, because the photo also showed defendant standing next to his friend, making gang signs and wearing gang colors. And the court said, you must redact that part of the photo out. So everything the court did minimized the prejudice that came from the photo. That in itself, plus the ample other evidence that the people presented at trial, rendered any error, any prejudice, if any, harmless in this case.
Thank you. Yes, go ahead. You wanted to say something else?
No, Your Honor, I was going to go over the other trial evidence to show that's harmless error, but if Your Honors would
including video evidence.
Yes, Your Honor.
Okay, thank you.
May I?
Go ahead.
Regarding the concession, I want to be clear. The people conceded both at the trial level and in the appellate papers, and I'm confident, indeed certain, that the papers will back this up, that the concession was that a generalized theory of access to guns is impermissible and there must be a sufficient similarity. I want to make the point again, it's not even that we know it's a small caliber gun. We don't know the caliber. A .357, which is a large caliber, can fit inside of a sweatshirt pocket. Indeed, the only evidence we have on this score is that—
Counselor, how do you respond to your adversary saying ultimately, if it was improperly admitted, it's still subject to harmless error analysis?
The picture which was attached to my brief is literally the defendant pointing the gun from the jury's perspective into the face of the jury. I don't mean to make a menacing gesture, but this is what the jury is looking at. That's as prejudicial as it gets. The fact that they acquitted on the top count.
Any picture of someone holding and pointing a gun could be characterized that way.
Well, yes, but that's what this was. And it wasn't him holding a gun on his lap or in a holster or on a dresser near him. It was him holding it and pointing it at the viewer. That's as prejudicial as it gets. It wasn't an attempted murder case to begin with. The gunshot was in the lower abdomen and there was no attempt to finish anyone off, to use a crass term. It was never an attempted murder case. It was overcharged to begin with. And that's why the jury acquitted on the top count. It was coupled with other prejudice that I described in other points of my brief. And I believe aspects of the summation further exacerbated that prejudice. It was a thin case. There was no ballistic evidence, no scientific evidence. The victim didn't testify. The surveillance video, I know the court's viewed it. Perhaps the court disagrees. I do not think it was that compelling. So it was a thin case.
Thank you. Thank you both. Matter of RC children.
Good afternoon. Kate Ferguson for Appellant Giovanni R. May it please the court. The family court abused its discretion by refusing to reunify this family when it was clearly in the children's best interests. Using the sole fact that the parents have not made a confession to prevent reunification was not in the children's best interest here, where the evidence demonstrated that the children were struggling and continue to struggle in what is now their 6th stranger foster care home, that the parents visited consistently, and that the family court's own independent mental health services clinician concluded that the parents not only completed but benefited from all of their services, such that any concerns were, quote, addressed by the current service plan. There was a number of pieces of evidence during the 1061 hearing that established that these children were doing poorly in stranger foster care. It was established that they were in their 4th foster placement and were about to be moved to a 5th foster home, and indeed were moved quickly after the 1061 hearing concluded. The agency's own case planner testified how traumatic each of these moves were on the children. In fact, the case planner noted that it was one of the most traumatic things she had experienced when she moved them from their 3rd home to their 4th home. This is why the parents rushed to court to try to prevent another more traumatic move. Additionally, the evidence established that the children, Ashlyn was missing therapy, that she had night terrors, that Giovanni had experienced a deep cut to his finger that the foster parent was providing inconsistent explanations for. In addition to this evidence that the children were struggling in their current foster care placement and were about to be moved, the court's own report that it ordered by the independent mental health services branch concluded that any concerns about reunifying this family were mitigated by the current service plan. This is notable because the MHS report consisted of an independent clinician conducting interviews with Ashlyn's therapist with the assigned—
This is Judge Singh. It's clear to me that what the court was struggling with was this concern, serious concern of physical abuse of the 2 children. There was a hearing on that. There were findings made. How does that interplay with the trial discharge?
Your Honor, while there are serious concerns here, that alone should not have prevented reunification in this case. And I would contend that the parents showed insight in other ways by visiting consistently throughout this case.
And by the way, can you tell me when this case began? I think the children were removed in 2016. Is that right?
Yes, Your Honor.
So they've been removed for 4 years now?
Yes, they've been removed for.
And when did the parents start treatment and going to programs, and how long did that continue?
Your Honor, the parents started immediately, and it continues to this day. So my client is currently in individual therapy, has done multiple different courses, all of the services recommended to him, and is continuing to participate in that treatment plan.
And they've been consistent in that?
Yes, Your Honor, they've been consistent throughout the case.
The 1061 hearing was when? Would you remind me, please?
It was in August of 2019. And the court itself
You can go ahead.
The court itself noted during the 1061 hearing and at disposition that it was never in dispute that these parents had done every service asked of them, that they had taken every step possible to reunify. The only real issue was that they had not elicited the confession. And
so the request was for them to, there was already a finding that they had of neglect, right? They consented to that finding of neglect. The request, is that correct?
No, Your Honor. So during the record, at one point there was a settlement where the mother would have consented to a finding of neglect and my client would have consented to a finding, but the court rejected it. And so it continued to trial, and that's when the final.
Right. So there was a finding of neglect, but no concession by them that they had committed to the facts as the court found them.
Yes.
But they had done everything they had to do.
Yes, Your Honor. And I would also note, as noted in the MHS report and in my client's own testimony, the parents did acknowledge that the injuries occurred while in their care. And as I said, I think they demonstrated insight in other ways. I also would just like to briefly touch upon the letter that ACS submitted last night. I just would like to note that I think it's extremely inappropriate to present to this court highly contested allegations that are still being litigated at the family court level, and that ACS is deeply wrong that these unproven, disputed allegations that, to be clear, my client disputes and has not had the opportunity yet to even file his response to these allegations in family court, should come to bear on this appeal.
Any further questions for counsel? You're talking about a letter submitted to the court.
Yes, Your Honor.
I know, speaking for myself, I haven't seen that letter, at least not yet. I don't know about whether my colleagues have or not, but.
Nor have I. No,
I haven't seen it.
Respondent?
Yes, good afternoon, Your Honor. Cynthia Cow for the Respondent, Administration for Children's Services. Your Honor, to understand this case, we need to go even further back.
You know, one of the things that seems different about this case that is so much not so in other cases, and look, we see a lot of cases of this type, is that the parents really seem to have tried to do that which was asked of them.
Well, Your Honor, I would disagree with that characterization. First of all, the findings were to abuse. Remember, there were 3 children, 2 of whom suffered broken bones, which were deemed later not to be accidentally caused or naturally caused. The family court rejected the father's story, and actually
but that was hotly contested, wasn't it?
Well, yes, there was a fact-finding hearing, Your Honor. However, there was a mountain of evidence that the mother had described a litany of specific incidents of physical abuse, domestic violence, targeted against.
When you say a litany,
yes, Your Honor.
How many, when you say a litany, how many are you speaking of? Because I could be mistaken, but I know the father said that he hit the mother on one occasion, and that the mother initially said that the father caused the youngest child, I guess, to have the break in the arm. Is there something else you're referring to when you say a litany?
Yes, Your Honor, I'm referring to the out-of-court statements that the mother made repeatedly to the hospital social workers, to ACS's expert, to the caseworker, some of which were corroborated by the 6-year-old child. And they include, I can describe them, but they can be found in ACS's brief on pages 7 through 10, 21 through 24. They included marks on Ian's back, bruising, a swollen lip. This occurred, according to the mother, 3 months before the broken arm incident occurred.
And Counselor, how long ago was that?
Which incident?
Broken arm. A few years ago?
Broken arm was in June of 2016.
Okay, so we're in 2020. The children are going through a series of foster homes. There is no question that the children have been harmed as a result of this. Isn't a trial discharge under these circumstances, given the demonstrated harm the children are suffering, and also under our case law, isn't a trial discharge proper at this point?
No, you're not, because the parents continue to deny that there are any issues in the home, even though it's clear that the two boys were.
So in other words, until the parents admit to the abuse, the children forever will be separated from their parents. That just does not seem rational.
We're not asking that the parents admit to the abuse.
Well, isn't that what the judge asked?
No, we're asking that the parents.
Isn't that what the judge asked?
Not necessarily, Your Honor.
Excuse me?
Not necessarily, Your Honor.
Not necessarily?
No, the judge is asking that they not continue to adopt or cling on to the account that the children were accidentally injured during a bath time episode, which is what they continue to.
So in other words, the judge is asking them to admit to the incidents before the children can be released for a trial discharge. Shouldn't the judge also be considering the harm to the children as a result of the series of placements in different homes?
Well, first, Your Honor, the court did consider that. And I can see that was not an ideal situation for these children. But that was also a contested dispositional hearing. It was not clear that the trauma of moving to this different foster home placement were the only reason why Ashlyn was suffering. She also had, she was suffering from the fact that she never got bereavement counseling due to the sudden death of her mother. That was never brought up. And the case planner who made these conclusions had no right to make. She was not in a position to decide what was causing this child's trauma. And I would submit that she cherry-picked some of the facts.
But the question still is this. These events happened in 2016. We see a lot of these cases. It's rather unusual to see one, let alone two parents over the course of 4 years follow all the requirements, go to whatever the requirements are with regard to their counseling and training and whatever else it is, be consistent and complete it. These parents continue to do so. Any other parent, if they, as you say, use the words that the judge wanted them to use, would have had the children back by now if they were completing these services. There's not been anyone who said that they don't seem sincere in the way they've completed the services. So the question is, what are they missing other than those words? What about their behavior suggests that if the children go back to them, they will not behave in a way that's consistent with the training and the example that they've shown over the last 4 years?
Well, to answer that question, Your Honor, the programs and services that they completed, we submit that it was not meaningfully completed. Yes, they got completion certificates of completion, but the father was going for domestic violence programs, anger management sessions, even though he said, well, I don't have that, I'm not violent in any way. The mother continues to support this notion that the children were injured by the bath time episode.
Did any of the counselors in the anger management or wherever say that he had not completed it satisfactorily? Do they give certificates out to people who don't complete the program satisfactorily?
No, we're not saying that he didn't go. Or he didn't.
No, I didn't ask you that. You said that they got the certificates as if. So what? So I'm asking you, do the counselors who run your programs give certificates out to people who don't satisfactorily complete the programs?
No, they do not. They do give out this.
So then where do you have evidence that they have not satisfactorily completed these programs?
Well, for one thing, the father stopped going to individual counseling. He went to 5 sessions over a span of 6 months. 5 sessions in 6 months. It's less than a month. And then he just stopped.
How many did he go to over the 4 years?
5 sessions in 6 months. There were recommendations by the MHS that he continue to receive counseling. He has not done that as far as.
But two things we have here is that the children want to go back to the parents, and they're heading to their 5th or perhaps 6th foster home. Am I missing something about that?
Well, Your Honor, to be fair, they have been in the same foster home for nearly a year now. There's been no other movement, and they've been adjusting very well. So that's.
But they want to go back to their parents.
Well, it's unclear whether they want to go back to the parents at this point. I wish the attorney for the children were here, but I can tell this court that there's been ongoing issues with the children, especially the older one, fearing the father, and now have decided that she does not want to visit him.
Thank you.
Thank you.
Very briefly, Your Honor, I just wanted to touch on a few points. First, I wanted to note that my client is in individual therapy. When it was reordered again as part of the amended dispositional order, he immediately got into therapy and has been attending consistently for the past number of months, at least since the beginning of this year. Second, I would just note that the parents participated in all of these services, and the independent MHS clinician concluded that they appeared to gain a lot from these services. ACS contends that they didn't meaningfully complete them for the same reason the family court below is refusing to reunify this family, because the parents are not making the specific statements that the court wishes they would make. But through their actions, these parents have demonstrated insight. And at this point, as Your Honors have noted, it's been over 4 years now. And if the family court continues to focus on compelling...
Where do things stand in terms of the children wanting to go back? I heard your colleague says that the older child doesn't want to go back.
Your Honor, this goes to the point I made earlier. These are contested allegations that are still being litigated at the family court level, and it's based solely on statements the foster parent has made at this point, not statements that Ashlyn has made directly to anyone. And so this is still being actively litigated at the family court below. But I will tell you that throughout the case, the children have consistently expressed their desire to be returned to their parents.
But counsel says, I guess it's Ashlyn, who's actually the father's biological child. She alleges that she doesn't want to go back.
Again, these are statements solely made by the foster parent that have not been fully investigated or litigated. They're not statements Ashlyn made directly to the agency or her therapist, for instance. So these are still being explored. And there's a larger context of Ashlyn has been struggling over the past few months. She made disclosures about abuse she had suffered at a prior foster home at the end of July. So if there's a larger context here, which is why I noted before that I don't think this information that is still being litigated at the family court should bear on the appeal right now.
Thank you. Thank you both. Keenan versus Christie's.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. In order to not go over my time, I would like to break down my argument into 3 separate subsections. The first will deal with the new theory claims in the briefs. Second will deal with Christie's liability. And the third will deal with Tishman's, the owner's liability. With respect to the new theory liability, you know from reading our brief that we long since abandoned formalistic legal pleadings. The question really, even in a 3211A7 motion, is not whether you've stated a cause of action, but whether you have one. And that's why all of the intermediate appellate divisions, as well as the Court of Appeals, has held in the absence of prejudice, even unpleaded claims or theories can be used to support or deny some.
Mr. Isaacs, why don't you tie it into plaintiff deposition? What did plaintiff testify on this issue with respect to this?
With respect to the accident, Judge Singh, or just more generically?
What's the accident? How he fell?
So here's what he said. It's on page 27 of my brief, and let me give you the pages to read. 547 to 549. From 545 to 547, he testified that he stepped over one of those lines, one of those grain lines that you see in the photographs that are from 666 to 669, which were designed to stop the condensation. And I'm going to read his testimony for you right now. Question: after you stepped over the pipes, did something happen? Answer: yes. Question: what happened? I slipped on a carpet tile and I went straight up in the air and I landed on my shoulder, my whole side. I landed on the pipes. The way they have it is spazzed. I think it should be spazzed. And then you carry over to 548 to 549. Question: when you slipped and fell, what happened? I slipped. I went up in the air. I landed on my side. I can't tell you how I hit the floor, but I landed like on the drain line and I did a nice header. You said you fell onto those floor drains. I fell onto the pipe like I flipped my body, so I can't tell you exactly how I fell because boom. So I think what happened is he came in, he finished eating, he stepped over one of the lines that you see in from 666 to 669. The carpet tiles that were placed there because this area was continuously dense. It was moist. It was wet because of the presence of the fan.
So in other words, he slipped on a wet condition, correct?
He slipped on a wet condition, but the wet condition, I believe, Justice Singh, was concealed under one of the carpet tiles. That's what they call them, carpet tiles. That was not affixed to the ground, that was not glued to the ground, and that, in fact, according to the testimony, had plastic on the other side that it was movable. So our position is vis-a-vis certainly Christie's, who employed the plaintiff who worked for Cushman & Wakefield. There is a recognized common law and labor law 200 duty to provide him with a safe place to work. The testimony was that the carpet tiles had been there for 2 years. The witness for Christie's, Mr. Yule, said he had been in the area 10 times, but he never saw the tiles, even though he had seen the drains. And our position is not seeing what other people say is there to be seen is not exculpatory, but inculpatory. It's certainly not a 240 sub 1 labor law case. It's not a hit in the rear, but I don't think I should necessarily lose summarily, especially when you consider Mr. Yule's testimony, and let me give you the page if I can, on 250 of the record, that he knew that the accident was being used as a locker room, and he said on 252 to 253 of the record that the Cushman & Wakefield workers were not supposed to be using that area because he said that it violated some undefined provision of the building code. So he didn't say what the building code is. I'm not sure he was right on the building code.
So the theory of liability is wet carpet tiles, or is it the failure to provide the plaintiff with a safe workplace? I mean, what precisely is your theory?
I think the theory is safe workplace based upon the presence of wetness. I would call it condensation as opposed to a prior spill, combined with the fact that these carpet tiles that had been placed down there for years, actually by a prior employee who was identified as Bob Leone, were not affixed in any way.
And Mr. Isaac, to know that from the initial instance that just said it was a wet condition?
I'm sorry, I didn't hear that, Justice Renwick. I
said they were supposed to know that from the initial pleadings that just said a wet condition?
Well, I think what the pleadings said, and I could give you the pages, 73 and 935, quote, in permitting plaintiff to use a floor, passageway, walkway, and/or platform, which was in a slippery condition, and then you go down three semicolons, quote, in failing to provide for adequate drainage, including but not limited to drains or such other adequate drainage on the floor on which plaintiff was working on. And then if you go to 934, this is in response to, I think, Christie's demand for a bill of particulars, paragraph 15, and I'm quoting, the above mentioned accident occurred when James Keenan slipped and fell on wet and slippery floor carpet due to a continuously clogged drain. Granted, it does relate to drain, but there's also testimony from the defendants, and Judge Renwick, I highlighted it with quotes, Mr. Pelletier on page 22 of the brief, and Mr. Ulsheimer, who was the chief operating engineer of the owner, on page 21, where they said that this condition itself, as shown in the photographs, was dangerous. They wouldn't have allowed people to stay there. And that it was, I think one of the words they used was horrible. So again, I'm not saying I win on summary judgment. I'm just saying I shouldn't lose summarily. And if I can just, I'm sorry, Justice Friedman.
Your time is up, but if you have something else you want to say, go ahead.
No, I will. I'm not going to go over my time. I'll take care of it on my 2 minutes. I'll deal with the owner on my 2 minutes. Thank you.
Okay.
Should I begin, Your Honor?
Yes, of course.
Thank you. Glenn Kaminsky with Amity Demers McManus, counsel for the respondent RCPI. I'm only going to address the unique issue that attributed just to RCPI as an out-of-possession owner. There is really no question, and the court below said there was no question, that RCPI is an out-of-possession landlord. RCPI submitted the lease, which demonstrated that RCPI was only responsible for the building systems up to the point of contact with Christie's space. That's 7.1 of the agreement, 1094 of the record. 7.2 says that Christie's, it's their responsibility to maintain the office premises. That's at 1094 of the record. As RCPI was out of possession, had no duty to perform non-structural repairs in the tenant space, RCPI cannot be held liable. In opposition, plaintiff failed to demonstrate that a specific statutory provision was violated or that a significant structural defect occurred. In fact, there's nothing in the bill of particulars to indicate an actual violation of a specific regulatory standard that would be applicable to here. This court, just 5 days ago, reiterated this rule in Estrella versus Rex Realty. So it's not something new. It's an out-of-possession landlord. The standard exists here. RCPI set forth a prima facie case to which the plaintiff did not refute. What plaintiff is attempting to do is to argue for the first time in the reply papers on the appeal that we're not completely out of possession. This is argued despite the fact that Christie's, through Cushman, was responsible for the drain in the area, and that RCPI was only responsible for its pipes where it was connected outside of the Christie space. Plaintiff submitted no evidence at all to show that there was a condition involving RCPI's pipes. Plaintiff testified that he made one complaint while he worked for BPR. So in the period before he was even working for Tishman, he stated, quote, "Just that one occasion for me." That was his testimony at page 764 of the record, indicating how many times he complained about a drain pipe problem. On the date of loss, the plaintiff himself did not say the drain was even backed up. That's 555 of the record. He could not recall when it had backed up last, 561 to 562 of the record. This testimony is all consistent with the coworker, Policia, Yule, Alzheimer. As such, summary judgment to RCPI was certainly properly granted. As set forth, as I already stated, and as set forth by the Supreme Court and in our brief, plaintiff is trying to switch theories from complaint to the BP, specifically 934 of the record, what they said, but because RCPI is an out-of-possession landlord, it's really not my issue. I can win without that issue. So we will rely on our brief and the record for those arguments and any other arguments. Unless this court has any questions for me, I yield my time.
Thank you.
Good afternoon, Your Honor. May it please the court. My name is Sophia Uvadev. I represent the respondent third-party defendant Cushman Wakefield. We were the employer for the plaintiff. I would just like to address a couple of points. One is, as was referred to this as this new theory, Mr. Isaac read to you portions of plaintiff's brief. And then I'd just like to read to you a couple of more sections. These are quoted on page 14 of our brief. And plaintiff was asked, as we sit here today, do you know what caused you to fall? And after an objection, he replied, the floor tile was wet underneath. And then he was asked a little later, what is it that you saw that looked wet? And the response was, after the fall, I was like, how did I fall? Question, what did you see? Answer, I seen the carpet tile was wet underneath. So this combined with their bill of particular responses saying it was wet, slippery because of a continuously clogged drain, framed this entire case from beginning to summary judgment when Christie's and RCPI moved for summary judgment dismissing the case, saying that they had no actual or constructive notice of this allegedly backed up drain or any kind of water condition. And you have plaintiff's testimony saying, I had been in that area multiple times that day, just 30 minutes beforehand, and I did not notice any wet condition. And you don't have any evidence of a recurring condition with a clogged drain. I think my colleague, Mr. Kaminsky for RCPI, mentioned that in his moving papers. So now you have plaintiff changing his story to say, in his papers below and on appeal, it was actually a variety of things. The room was cold, it was being used as a locker room, the carpet tiles weren't secured. Now, plaintiff on argument said, really, it was just condensation that was hidden by a carpet tile. All of these things weren't actually pleaded below, and this court has consistently held that you can't raise new theories of liability on opposing summary judgment. And it doesn't matter if we have different pleading standards, that's the law. And just in April of this year, in Silber versus Sullivan Props LLP, this court, Justice Friedman also presiding, reaffirmed that in a slip and fall case where it started out as a slip and fall in an entryway of a marble saddle, and they originally said it was wet. And then they came back and said, well, really, it wasn't just that there wasn't enough friction, but it's also that the building code wasn't complied with because, what did they say? The riser, the widths weren't sufficient, the riser heights weren't right, the tread widths weren't right, the handrail that he gripped when falling down wasn't right. And this court said, no, those are new theories. You can't raise it in opposition to summary judgment. So in terms of that, the Justice Jaffe correctly determined below that these were new theories, they couldn't be raised. And as we argued in our respondent's brief, even if you were to consider all of these issues, he still doesn't raise the question of fact. There is no testimony from plaintiffs saying the carpet tiles in and of themselves, when they weren't wet, were slippery. Plaintiff said Mr. Palaccia testified that they were unsafe. Well, Mr. Palaccia actually testified that they were, quote, not unsafe. So there was a not in front of the word unsafe. He said they looked untidy, but that's not dangerous. It's just doesn't look nice. They have somebody from RCPI or Alzheimer who had no personal knowledge, said he had never been in the room before, had never seen the tiles. He was shown a picture of the tiles at a deposition and said, well, those kind of look unsafe. But again, he doesn't have personal knowledge, and a witness without personal knowledge can't raise a question of fact, especially when you have nothing saying the plaintiff slipped because these tiles were slippery, not because the condition was wet.
Any other questions for counsel? Thank you.
Thank you.
Christie's.
Good afternoon, Your Honors. When I listen to the plaintiff's claims, I'm thinking to myself, he's come up with the complaint where he doesn't mention the carpet tile. You look at the bill of particulars where he doesn't mention the carpet tile. You look at his deposition testimony where he states that he fell because they were slippery carpet tiles. The idea that Christie's somehow knew of this or should have known of this, Mr. Isaac mentioned that Tim Yule had been in the room approximately 10 times before. The plaintiff's testimony himself indicates that Christie's never knew about this, that he never informed Christie of any moisture or wetness in the room, that he never informed Christie's that the room was cold, that he never complained at all to Christie's about the conditions in the mechanical room. There's no testimony, there's no indication that Christie's caused or created this condition, that there was a backed up drain that caused this condition. The plaintiff himself entered the room on the day of the accident. He walked across the room in the very area where the carpet tiles were, where he had the accident. He took his equipment off, he hung it up. He walked back across the very same area, sat down and ate his lunch. He then finished his lunch and walked back across the area, and that's when he had the accident. So within a 30 to 35-minute period, the plaintiff walked in that same area twice without noticing any problems with the area in question. There clearly was no notice to anyone else. No one entered the room in the time that the plaintiff was in the room eating his lunch. There is simply nothing before the court that indicates that Christie's had notice of this condition. With respect to the changing theories, the alternating theories, we had one theory that was put forth in the complaint, another put forth at the deposition, another put forth at the summary judgment level, and now here we are at the appellate level, and we have yet another theory that the plaintiff is propounding. I just wanted to note that the plaintiff mentioned that this could fall within the label or 200 realm. That's inaccurate because the plaintiff specifically abandoned any claims with respect to label or 200 in his affirmation in opposition to the summary judgment motion. I can yield my time if there are no questions.
Further questions? Thank you. Mr. Isaac?
Mr. Isaac, you're muted.
Mr. Isaac, we can't hear you.
Sorry. I'm sorry. I'm unmuted now. Can you hear me now?
Yes.
Yes, sorry. There is no changed theory here. If you look at the Bill of Particulars, the entire theory in the Bill of Particulars was that he was not provided with a safe place to work. Whether it's under Labor Law 200, the common law is irrelevant. Labor Law 200 is a recodification of the common law. And the fact of the matter is that the questions that were asked and the evidence to which I referred mostly came from the defendant's lawyers. So for the defendant's lawyers to say, I don't know what this case is about, when the very evidence that I'm citing came from the questions they asked primarily to the plaintiff at the deposition, refutes itself logically and syntactically. I also heard.
This is Justice Kennedy. I would like to know, how do you respond to RCPI's argument that they were not contractually obligated to make repairs or to maintain the mechanical room?
So, Justice Kennedy, let me give you the page references to which I'm talking. That's clearly my weakest case. Mr. Kaminsky is correct. There was a very, very complicated lease here, but the lease broke down into two different areas. Right? One was the office premises where there was a responsibility. The other was the auction premises where there was not. That's on 1094 of the record. Mm-hmm. Now, as a general rule with the auction premises, the defendant, the owner, would not have any responsibility except where the system itself serviced the entire premises. And I'm specifically referencing, Justice Kennedy, 1206, independent systems, line 1, 2, 3, 4. And it says other portions of the buildings. If you look at 563 of the record, 770 and 771, you'll see that there was testimony that the drain and the lines in the mechanical room actually went down to a Tishman Spire area so that it serviced both premises. So Mr. Kaminsky is 100% right. Out of possession landlord, no liability. But there was evidence here in the lease, in the testimony, and in plaintiff's testimony regarding plumbing that would evidence some degree of control, which would establish liability either under a course of conduct.
And Mr. Isaacs, when was that issue first raised, that in fact the owner wasn't really out of possession, at least with respect to this space?
Well, I don't think it was that he wasn't out of possession. I think that there was a response. It was raised below, and it was raised.
When was it raised, Counselor?
I'm sorry?
When was it raised?
I think it was raised in connection with
summary judgment.
Yes, in connection with the discussion of the testimony and the discussion as to the lines as well. That's why I tried to give you the page references. Okay. I think I'm over my time.
So
any other questions for counsel?
Just one more. So is counsel also right that there is no evidence of any significant structural or design defect or violation of a particular statute? Is he also right with that?
I think Mr. Kaminsky is right in the sense that there is no identified code violation here, which I think is probably required under your older decision in Manning. There is evidence that the plumbing and the drainage lines are structural in nature. When you look at the lease, and I'm referring to 1094 and 1095 and 1204, you can skip 1205 and go right to 1206.
But the slip and fall wasn't on a structural, if that's structural, it was on a loose carpet tile. So how do you tie the two together?
Well, I'm not sure that anyone's 100% sure how the area became completely wet. If you look at the photos, Justice Singh, on 660 to 669, it's a very unusual area. Nobody would be working there. Nobody would have a rec room there. You have an open drain and you have actual pipes that are sitting there to stop condensation. So part of the theory was that there was general wetness emanating not just from the machinery, but from the actual work that was done there. And if in fact that relates to the plumbing system or any of these other structural systems that deal not just with the auction part of the premises, but with the actual office premises as well, there's a potentially cognizable theory. It's not that I have to prove a case, it's still a summary judgment motion where the defendants have to disprove my theory.
Any other questions for counsel? Thank you. Thank you all. Thank you all. Patmos Fifth versus Mazel Building.
Good afternoon, Your Honors. My name is Steve Harfinis, and I represent the appellants. This case presents a extraordinarily peculiar set of facts in a mortgage foreclosure action that has resulted in my clients being determined by Supreme Court to have released $10 million of an unpaid loan. So how did that happen? And this court's very familiar. I know, Justice Renwick, you've been on every panel of the 3 times that this case is.
Not everyone, 2 of them, I think.
I thought it was 3, but maybe I was reading. I could have read it wrong.
Yeah,
I know
Judge Singh, under the SEMA, wasn't Supreme Court right that there was a release, at least with respect to the building?
No, and I'll tell you why. There's a fundamental error that Supreme Court committed when it determined that the mortgage between Mazel and Patmos was divisible. So going back to the early portions of the 20th century, the courts have held, including this court, and it's well recognized now in treatises, that a single mortgage is indivisible. You cannot break up the mortgage into multiple pieces and provide it to other parties unless there is consent of the mortgagor. That didn't happen. So what these documents...
So what is the effect of the Weiss party's release of the mortgage on the 52nd Street building? Are you saying it has no legal effect of any kind?
It has a legal effect, Justice Singh. It eliminated their participation in the proceeds of the mortgage. So this area of mortgage law has developed in a fairly peculiar fashion. We started with the premise that you cannot say it differently. The mortgage is indivisible. What you can share in and what is divisible is participation in the revenue generated by the mortgage. And candidly, the documentation in this case was inarticulately done by the lawyers. And there's a reason for some of it because of the peculiar procedural history here, but the fact remains very clear.
What's the effect of our having said on an earlier case that the deed was a statutory mortgage?
Well, that goes to a separate point, Judge, and it raises an issue of first impression. The effect is that created a second mortgage unencumbered by the transactions between the Weisses and Mazel, and the debt which is recognized, that mortgage securing the debt on the notes. So in other words, when this court converted that deed into a mortgage, it created an enforceable interest based on the promissory notes that were issued by Mazel. So in theory, the parties my client could have foreclosed simultaneously on both on both the statutory mortgage and the non-statutory mortgage.
And are you seeking to foreclose on the statutory mortgage or just only on the consolidated mortgage?
Well, we did seek to amend our complaint to, after this court's decision, to foreclose on the statutory.
Well, you take it whichever way you get it.
Yes, I think that's a very fair statement, Judge.
But at this point, are you seeking to foreclose on the statutory mortgage?
We would, yes, we would.
You are.
Yeah, we asked the trial court to permit us to do it after this court's decision, and the trial court rejected our ability to do that.
Okay, so you're still pushing that issue.
Correct. I mean, and it rejected it without any analysis. So effectively, what would have happened based on this court's conversion and correctly of the deed to a mortgage, that would take us a instrument that was clearly designed to be security, although the wrong one, and effectively make it remediless. In other words, under what Justice Jaffe did and what the plaintiff Patmos contends is you don't get to foreclose on the statutory mortgage because you had another mortgage. Not surprisingly, they don't cite any case law on that issue, and I don't blame them because there isn't any. But that would we don't read statutes that provide you a remedy to vitiate them just because there are other peculiar circumstances in there. It would, in theory, be no different than having a first and second mortgage based on the same debt. And the case law, what they do is consolidate would consolidate the two obligations. But here's where the problem really occurred here and candidly, it was poor lawyering in the use of the documents that were designed to conduct the transaction. And anyone looking at the transaction would say that these guys actually exchanged planned to exchange $10 million and then ultimately exchanged $10 million on a handful of assignments and documents that were filed on the record without a document. And it would be a reasonable question if you didn't know the way these folks had done transactions. And for better or worse, unfortunately, I've represented them before and seen these types of transactions that are basically old school based on trust. These are all folks who know each other for a long time. Many of them came over to the United States from Israel at the same time. They're all self-made folks. A handshake still means something. So, but what these assignments that were filed that the trial court deemed released a party who did not participate in them. What they really are participation agreements. And the participation agreement allows the two parties to share in the proceeds of the mortgage because the mortgage is indivisible. And in fact, even if they're old cases, it's from like 1910, but it's cited in most, and they're in our briefs, and it's in the treatises that have come out subsequently. Even if that assignment is made, that assignment does not affect the assignor's right to foreclose on the entirety of the obligation.
I'm going to stop you at that point, counsel. Any other questions for counsel? Okay, you have some time in response, so let's hear from the respondent.
Good afternoon. May it please the court, Charles Fitzpatrick, on behalf of respondents Patmos Fifth Real Estate, Inc. and Patmos Westbury, LLC. This case involves a complicated web of financial and real estate transactions dating back more than a decade. But the question currently before the court is actually very straightforward.
So let me ask you first, what do we do with our prior holding that this is the deed was a statutory mortgage?
Well, Your Honor, a couple of things. Mazel is now shifting gears.
That's a problem for you, isn't it? That we called it a statutory mortgage. You cannot walk away from it so easily.
No, I don't think that it's a problem, Your Honor, and here's why. Mr. Harnfinis says that Mazel is now trying to foreclose on the statutory mortgage, but there is no claim in this case to foreclose on a statutory mortgage. There's only a claim to foreclose on the consolidated mortgage. There's nothing in their claims that says statutory mortgage or foreclosure on anything other than the consolidated mortgage. In addition, if you look at their briefs, Your Honor, they actually admit that here the statutory mortgage is really the same thing as the consolidated mortgage. They're not different. And you can see that on page 29, footnote 12 of their brief. And because the statutory mortgage is really the same thing as the consolidated mortgage. It's subject to all the same.
Counsel, that doesn't make any sense to me. That seems completely opposite to what we said in our holding as to what the impact of that deed was. It gave him an interest, a security interest, and that the lender had to proceed in a foreclosure proceeding like any other normal foreclosure, no?
Yeah, well, so, Your Honor, I think if you look at that opinion, and that's from June 16th, 2016, what the court said was the deed was given to secure an extension of the mortgage and an additional loan. So it's tied into the same consolidated mortgage. It's not something different or something new. It's just part of the same thing. So it's not an entirely different mortgage. And again, Your Honor, there's no claim here. There's nothing in their counterclaims that says we are foreclosing on a statutory mortgage. They're only seeking to foreclose as to the consolidated mortgage.
Okay, fair enough. Then how do you respond to counsel's point that the SEMA is not divisible, and that in effect what you have here is a participation agreement?
Well, so one, Your Honor, I don't think that this argument about not being able to divide the mortgage was ever raised before.
Is that a legal issue or is that a factual issue?
It sounds like a legal and a factual issue as to whether or not it was.
What's the factual issue? What's the factual issue that we would have to decide whether or not a mortgage is divisible?
Well, so fair enough, Your Honor. If the only question as to whether it can be divided, I suppose that is a legal.
So, but is counsel correct that a mortgage is indivisible? I mean that's what our cases hold.
I don't believe that is correct, Your Honor. And as again, it has been argued before, so I'm not prepared to give you a cite to the contrary, but it's not something that's ever been argued before the court before. And I think it's important that it has been argued before because the doctrine of judicial estoppel. This is not the first time that Mazel has been before this court. The last time they were before this court, they argued time and again that the mortgage had been divided. It had been divided into two interests, a 37.5% interest and a 62.5% interest. And because of that division.
And how would judicial estoppel apply? It seems to me that the defendant has not benefited from any of our rulings here. In fact, it's been the plaintiff. So how does judicial estoppel apply to that?
Well, Your Honor, to my knowledge, the First Department has never held that a party needs to prevail in order to have the doctrine of judicial estoppel.
But isn't that the whole point of estoppel, that you prevail on an issue before a court, and then you can't take an inconsistent position down the road?
I think that's one reason why judicial estoppel exists, Your Honor, but I think that it also exists that you can't be constantly shifting back and forth from one set of arguments to another. You have to be consistent. That's the way it's supposed to work. Also, Your Honor, if you look at this court's decision from Mazel's prior appeal, it's not a situation where the court did not accept Mazel's position, which was that they had divided the mortgage into two parts and could no longer foreclose as to the 62.5%. What the court said was essentially, yes, that is what happened here, but those facts are not the reason why the appeal was denied. The appeal was denied because accepting those facts as true, the new counterclaims that Mazel wanted to assert to claw back that 62.5% interest were barred by the statute of limitations.
Any other questions for counsel? Mr. Harpenist?
Yes, Judge, I'll try to be as quick as possible because there's a number of issues that have been raised. Counsel is incorrect on the application of judicial estoppel. Justice Singh, you're spot on correct. We have to win in order to be judicially estopped. This court has ruled on that in Chatsworth Realty versus New York State Division of Housing Community Renewal. It's in our brief. So we're not barred by judicial estoppel. The statute of limitations issue doesn't. It's a red herring. It's going to relate back under 208. I think it's B, if I remember correctly. Could be C. So
it goes back to 2013, doesn't it?
Correct.
It should make it timely.
That's correct. And the fact of the matter is that Justice Jaffe prohibited us from amending the we have to look back at the application that was before. We asked to amend the complaint to add the claim for the statutory mortgage, which only arose when this court's decision vitiated the deed and converted it to a mortgage.
And I'm sorry, did you appeal the denial of that motion? Is that before?
That's before you now.
Okay.
Yes.
What about your adversary's point that with respect to you can't separate the mortgage, that wasn't raised before?
Well, I think you, Justice Singh, I'm not trying to dump too much credit on you, but I think you nailed that on the head too. It's a legal issue as to whether or not it's splittable. It's found directly on the face of the record. There are no new facts that would necessarily be there, and it was touched on the fringes of the lower argument. And I didn't represent my clients on the arguments in the papers in the lower court, but it is on the fringes of those arguments. But that doesn't really matter because this court has a long line of cases that say if it's on the face of the record, doesn't require new factual development. Here it clearly doesn't. This record couldn't be any more factually developed. As it relates to this issue, the record was factually developed probably in going back to the first decision when Justice Renwick was on that panel. So the court clearly can consider it, and it should consider it. And we got to keep in mind the adverse impact of all this. We're not talking about $50 or $20. We're talking about a windfall of $10 million. Now, maybe the number in and of itself shouldn't have an adverse impact on the decision, but you have to look, the fact that
But it's something you want us to consider. Any other questions for counsel? Thank you. Thank you both.
Thank you very much, Judge. Appreciate your time.
Thank you.
Bavers versus Shepherd.
May it please the court, Stephen Popovsky for the appellants. The court below stated correctly that Mr. Zubli had the power to make certain corporate governance changes because he represented 100% of the shares. But the court found that he didn't dot his I's and cross his T's and therefore hadn't done so effectively. Zubli's owned 50% of the shares. 2 weeks earlier, Plaintiff Catan had put his 50% into an irrevocable trust, making Mr. Zubli the trustee, with authority to do all things related to the operation of the business that Mr. Catan could have done. There are 3 documents that make Mr. Zubli's intention crystal clear. Briefly, first, Mr. Zubli and his wife, the only 2 shareholders, entered into a new shareholders agreement, providing that the shareholders agree to exercise, as soon as practicable, any and all voting rights to elect the following individuals as directors. They identified themselves. Second, they adopted bylaws providing the board will consist of 2 members. Third, they executed written consents, the first sentence of which stated the undersigned, meaning Mr. Zubli and his wife, constituting all of the members of the board of directors. These were family corporations that had operated informally for 30 years. The sole 2 shareholders had the power to name themselves the sole 2 directors. Nobody's disputed that they intended to do so and that they tried to do so. There are 2 cases, 2 appellate division cases that say that was enough to make it so under these circumstances. Respondents then say, well, even if they became directors, they didn't replace the prior directors, so at worst, Mr. Catan was still on the board. But the bylaws say right there, the board will consist of 2 members, and they sign the consents as all the members of the board. Respondents' counsel argued to the court below, evidently quite effectively, that all of this was done in the dark of night. But less than 2 weeks earlier, not only had Mr. Catan intentionally relinquished control over the companies, but that relinquishment was necessary to accomplish the very purpose of the trust, to get the intended tax benefits as well as protections from creditors and from his estranged wife. And Mr. Catan likes the benefits of the trust. Despite all this litigation, he's never sought to rescind it. They complain that Mr. Catan wasn't notified that he was no longer a director. But if someone tells you to do something,
to create the impression that when that happened, I think it was December 28th, that Mr. Aki Catan is brought in, not really realizing what's about to happen, that he's about to turn this over to his brother-in-law and perhaps his nephew, and he really wanted his sister to be the trustee, but that they tell him, oh, she's not here, so she can't be named the trustee. And he's sort of caught unawares.
I'll address the sister, Your Honor. They refer to Mr. Zubli as only a temporary placeholder trustee, And they said she could not physically be in the office at that moment. But respondents admit, this is in their brief and in the complaint, Mr. Catan didn't install his sister in place of Mr. Zubli for 23 more months. So that's just, you don't have to credit that. It's just not true. In fact, Mr. Catan stated in the trust that he had confidence in Mr. Zubli's, quote, individual skills, and that Mr. Zubli was, quote, most appropriate to serve as trustee because of his longtime involvement with the properties. I want to address the notion that he wasn't notified that he was no longer a director, Your Honor. If someone tells you to do something and then you do it, it's not wrong or suspicious if you don't tell them you just did it. And here, despite pages of briefing, respondents can't point to any legal requirement that a director be notified of his or her removal. But no question, if a removed director purported to exercise managerial authority, of course, then they'd be told, you're not on the board anymore. That didn't happen here because Mr. Catan, by his own admission in the pleading, acted consistently with his authorization, with the trust purpose, and with his removal. For 4.5 years, he disappeared and did nothing in terms of corporate management. He told Mr. Zubli to manage the companies alone. He let Mr. Zubli manage the companies alone. Then a half-decade later, his lawyers popped up and said, what? You were managing the companies alone? Everything you did was ultra vires. They also argue that under the prior shareholder agreement from 2005, Mr. Catan had an express right to nominate company directors. But the 2013 shareholder agreement expressly superseded previous such agreements. In that word, superseded. So all the prongs of declaratory relief requested in the first cause of action that relate to the corporate governance should have been dismissed. The remaining prongs relate to certain mortgage loans Mr. Zubli took, which they claim falsely on the documentary evidence stripped the properties of most of their value. All of the loans were repaid in full.
Are they referring to that? Are they referring that there was rent monies that could have been distributed, which your clients were using the property probably without paying rent, and that's where he lost out?
I'm glad you asked that, Your Honor. There are 2 agreements signed by Mr. Catan that factually negate those allegations about use of the properties. The 2000 Guardian lease expressly stated that Mr. Zubli's entity could use the property, quote, for any purpose whatsoever, so long as it is legal. And the 2005 shareholder agreement, page 117 of the record, Mr. Catan reaffirmed that the Zublis were maintaining and using the properties on their own to make money or lose money in exchange for guaranteed monthly payments, almost $1 million over 15 years, while Mr. Catan paid no expenses and did nothing except cash his checks.
Okay, any questions for counsel? Thank you.
Thank you, Your Honors. Craig Flanders from Blank Rome for the respondents. I'm going to address the 2 issues which were raised.
You know, I have a question before you start, and I don't know that it's determinative of anything, but it occurred to me, there is an attempt sort of to say, like, there was some deceit going on in that December 28th execution of documents. And of course, there was an attorney there who was representing both of them at the same time. And I don't know whether that's something which should be done or not, but I don't see ever that there's any action taken by your clients against that attorney. So how does that fit in with these claims that what went on the December 28th, there was some impropriety on the part of the Zublis?
Sure. Well, there's a background there, and there was, I think, not equal sophistication among the parties. So the Zublis brought this trust and estates lawyer, Mr. Buklis, to the table. They went to our client and said, listen, for tax purposes, we should all put our shares into trust. And a few hours before going to the lawyer's office, and the Zublis drove them there, they presented Mr. Catan with a 50-page agreement. It said, look at this, scan through it. And then they got to the office. Mr. Catan said, I'd like to place my sister as trustee. They said, sorry, she's
then he waits 23 months before he puts her in.
Yeah, but that needs to be put in context, right? Not the most sophisticated person. He had put, his nephew, who he trusted, in place. He is not aware that 9 days after this trust is signed, 9 days, these companies were in place. Him and his brother-in-law were the directors and officers of these holding companies for 30 years. 9 days after this trust is signed, all of a sudden there's a series of completely out of ordinary course corporate governance changes that are being made, and this is undisputed, without telling our client, without telling the beneficiary of the trust, and that continued to be the case for 23 months. So our client didn't know that there had been all of these corporate changes. Those documents didn't come to light until 2016. And why did he not know? Because none of the corporate statutory requirements for providing notice to existing directors and officers and providing notice of shareholder activity on consent outside the normal course of a meeting were done. So this is not a situation where we say, hey, I'm going to hold you to this really onerous corporate formality. These are corporate formalities that deal with the removal and election of directors and officers, and corporate formalities that are designed to protect minority shareholders or officers or directors that are not effectively.
And also, obviously, we're dealing with a pleading motion, so you've got a lot of latitude.
That's correct, Your Honor. And not only do I have latitude, but they came in to put this in context. They came in, we put together an extensive complaint. As you can see, we take these pleadings very seriously. They came in and they said, not only do I have a smoking gun document in my hand that's going to kick out all of these claims, but it is such a slam dunk that even filing this lawsuit is patently frivolous. Even more, it's malicious. And they accused me personally, my firm, I've never been sanctioned in my career, okay? They accused us of frivolous activity just for accessing the courts through claims. And what was that document? That was a trust agreement with Ari Zubli. There are 9 defendants in this case. Only one of the defendants is even a party to the trust agreement. Mr. Zubli was only the trustee till November of 2014. The claims go through the filing of this case in 2017 and actually after that. So right off the bat, we have claims that are way outside the scope of time, way outside the scope of parties of a trust agreement.
Let me ask you about a couple of things that appear in the Aki Cotton Irrevocable Trust, and you can tell me where this fits into this case and what its significance or lack of significance is. Page 167 of the record of the Aki Cotton Irrevocable Trust, paragraph 2C, B2C. Well, it's C. It's section C. Authorization of conflict of interest. The grantor has appointed the persons named in this agreement as trustee hereunder, cognizant of the fact that they may also serve as general limited partners, which may form, and it goes on. It sort of like authorizes the conflict of interest, and similarly at page 180 of this agreement, 180 in the record, page 34 of the agreement, conflict of interest waived. The trustee may exercise the authorities granted under this article, even if the trustee shall own personally an interest in the business. Aren't you sort of authorizing the nephew to do whatever he wants?
No, because that reading would be precluded by 11.17 of the EPTL. This is just an authorization that says, hey, you're not going to, these are closely held businesses. If you are able to participate and become a director pursuant to the corporate governance procedures, it's okay if you have a conflict of interest. You're not going to be precluded from that by conflict of interest. But what it doesn't say is that you, Ari Zubli, can use your position as a trustee to completely disregard any rights of the beneficiary at all, use it solely for the purpose of taking control of the companies. And what does he do as soon as he has control of the companies? He immediately, we're talking weeks, authorizes himself to take millions and millions of dollars, okay? Now they're saying, oh, don't worry, it was paid back. That, of course, is not an excuse. It was an interest-free loan. It was a loan to the companies. They distributed only to one shareholder. They didn't make that money to us. So their reading is because there's a conflict waiver that somehow Ari could act solely and exclusively for the benefit of his side of the family, ignoring the beneficiary. The EPTL precludes that reading. And more importantly, this is a trust agreement. Trust agreement governs the trust property. The trust property here are shares. There is an effort here to conflate the rights of a shareholder and the rights of officers and directors. Of course, you could be an officer or director without being a shareholder.
I don't mean to imply that it determines what happens on this sort of a pleading motion appeal, but was there a course of dealing as to that property? Hadn't the Zubli side of this equation been using that property sort of as they wished?
Sort of, Your Honor. So there was a deal in which Isaac Zubli was using the property and he would pay the property taxes. And there was a deal cut that's reflected in a 2005 shareholder agreement, which names Mr. Catan as a director and officer and says that he has the right to nominate an officer and director even after he assigns his shares. And what that says is that Mr. Catan will agree to a finite profit for a finite period of time, but that period of time ends when certain events end, when the guardian lease ends, when there is an assignment of any shares. So that deal in which the Zublis could use the property and Aki would only get a finite amount, that ended with the formation of the trust on December 28th, 2012 by its own terms. And this is, again, the terms under the 2005 shareholder agreement. So, yeah. If I can make one other
you want to say, because you're
I do, yeah. One other point. He mentioned that the guardian lease somehow authorized them to use the properties and to have all these defendants just get 100% of the money on the properties for their own benefit. The guardian lease at the latest ended in 2015. We've gone through discovery in this case. This is a dismissal motion. We've gone through discovery now. It's been 2 years. And there's evidence that's outside the record here that Guardian didn't even exist as of 2015 and had abandoned it. So that Guardian lease, A, requires approval for subleasing. So they weren't allowed to sublease. There's no evidence there was ever approval. And B, it ended. The claims go way beyond 2015. So the documentary evidence wasn't even close to granting dismissal here. And their efforts to affirmatively say that this document was a 110% slam dunk when it wasn't even a 10% argument, while at the same time seeking sanctions against us, which they haven't even attempted to say had any basis in the law at all. It's the one thing of the various orders that they don't challenge on appeal here. That combination of things is what got them sanctioned in this case.
Well, speaking only for myself, it didn't really seem like a sanctions case. But any other questions for counsel? Thank you.
Your Honor, 3 quick things. It is a pleading motion, but it's based on the documentary evidence. Counsel says that his client was duped into the trust agreement, but Your Honors should note that he has not sought to rescind it. He likes the trust agreement. He wants it. He wants the benefits. He's retained the benefits of it. So the duped is questionable on the documents and on the admitted facts. Counsel says all of a sudden these actions were taken. That's not suspicious. That's a matter of course. Mr. Catan gave up control to Mr. Zubli. He said, here, you run the companies. Not only did he say that, he had to say that to get the benefits of the trust. So he told Mr. Zubli to run the companies, and Mr. Zubli then went out and ran the companies. He had the power to do it. Justice Ramos admitted that. He had the intent to do exactly the corporate governance things that he did. And the law, the St. Mark's case, the Leslie Semple case, allows him to do those things by informal decisions reached by all the shareholders. All the shareholders have the power. These are technicalities, formalities, but the shareholders have the power, the ultimate power over the business. Second point, Your Honor, so many of their allegations on the documents, the 2005 shareholder agreement, counsel says it ended upon the trust. I don't read it that way, that upon Mr. Catan giving his shares to his trust ended it. But the fact is, admitted in the pleading, the payments continued. The parties continued with the agreement. Mr. Catan said, you go do what you want with the properties, and you're paying me every year almost $1 million in total. And after 2012, the parties continued that arrangement. He took the payments. He can't have it both ways. He can't take the payments and then say that the authorization to use the properties ended but I'm entitled to be paid for it. It's one or the other. And we were entitled to keep using it. We paid him for that right. The third thing, Your Honor, is just on the mortgages, very briefly. They were repaid in full. Respondents had actual knowledge that they were repaid in full months before they made the allegation that they were stripped of the value. The mortgages were publicly recorded, and they complied with the documentary restriction, 80% of either side's pro rata interest. Mr. Catan knew exactly what the Zublis were going to do, and the record reflects that he authorized it, even if it doesn't reflect the knowledge. And since counsel went outside the record, the attorney, Mr. Buklis, testified that he went through every clause of the trust agreement, line by line, with Mr. Catan, who understood it. So this is all made up, Your Honor.
Any further questions for counsel? Thank you. Thank you both.
Thank you.
People versus Murray.
This is Abigail Everett for appellant. Can you hear me? I'm sorry.
Yes.
Okay. Abigail Everett for appellant Hassan Murray. I begin with the argument that the court below erred in allowing prejudicial propensity evidence from a field intelligence officer who testified that the co-defendants, including my client, were seen at all hours frequently in all weather on a particular corner that was a high crime area. Now, respondent argues that this is not evidence of criminality, but rather it was introduced solely to show that these people were close friends. I submit that no reasonable juror could fail to miss the implication of this field officer's testimony. He testified that it was his job to identify people in his sector with extensive criminal histories, recidivists, to know where crime was happening, and that this corner was an area where crime happened frequently. So now the co-defendant's lawyer had argued below that this was more prejudicial than probative. And I submit that even if it has some minor value to show that they were friends, something that was established anyway through their Facebook accounts and other evidence, that the prejudice was enormous in this case. Turning to, yes.
Yeah. Okay. I was just going to ask if you would turn to the alternate juror. And
sure.
Yeah.
Sorry. All right. So I'm asking the court to have a bright line rule in this case regarding discharge of the alternate juror. The case previously, actually, that both I and Justice Friedman were involved with, People v. Brown, I want to point out is a case not only where it was unpreserved as opposed to this case, but also in that case, the alternate juror who'd been dismissed was still in the courthouse. This is not the case here.
Counsel, what is your bright line? What's the bright line you're proposing in this case?
Anything beyond de minimis. I think.
Okay, so what is de minimis when you in relation to CPL 270.35 Prince 1? Does de minimis appear anywhere in that provision?
No, I'm taking that standard.
Let me finish.
Sorry.
So you're essentially asking us to engraft a temporal requirement on the statute, right?
Well, actually, this court previously invoked the de minimis standard in Brown and Pearson.
That was, I'm sorry, counsel, as you acknowledge yourself, that was in dicta. So, yes. So it's really, so that case, is that case, but it's dicta.
Yes.
So in this case, you say 10 minutes, 15 minutes, 5 minutes. I mean, what's de minimis for you?
For me, I mean, if the slate were clean, I think the court, once you're discharged, you're discharged. But
let me ask you this. In the Brown case, you said the person was in the court. Are we talking in the building? Were they in the courtroom? Is there any clarity to that? Were they in the jury room?
They were, I believe they were, it says in the courthouse.
In the
I
court,
don't think,
I thought was what I saw.
I believe that's what it says.
Why does that matter?
Is that relevant that they should be, that they're in the building versus in their own home? Or should it be that, as you said, once you're discharged, you're released? And from that point on, that should be the line?
I think Judge Singh, I believe, pointed out the statute 270-35. If you look at that, first of all, it says that the court should not be discharging alternate jurors until the jury begins its deliberations. And then
we all would have
statute
avoided
says-
this problem, for sure. For sure, it would have avoided this problem.
And then the statute also says in that situation, the court, there's two things. Either you discharge them or you instruct them, if you're going to keep them around, you instruct them that they shouldn't be discussing or accessing information. So in this situation, once you let the jurors...
So is there reason in this case to think that they accessed information?
No, there is not.
Okay.
However,
Now you say that it's de minimis. Now, suppose they live a half a block down from the courthouse. Does it matter whether they're still in the courthouse or they're in their home?
I would say that de minimis is going to have to be a factual question. In this case, we're talking an hour and a half and they had gone home. So that wherever this court wants to draw the line, I would say that it's not de minimis.
What if it had been 45 minutes later?
I think personally, once you get out of the courthouse and you're able to interact with other people.
So you
and
want to
access
matter
rules,
if on this requirement that they not have left the courthouse, even though the statute doesn't say that.
The statute doesn't say anything at all about de minimis, correct?
So again, this is an example of just what kind of slippery slope there could be. The factors have to be whether or not, I imagine, one of the factors you were about to say was whether or not they had spoken with anyone, whether or not they're beyond the building, how much interaction there've been. You started to...
Well, actually, more than that, Your Honor, I'm focusing more on opportunity to do all those things, because I don't think the judge should be in a situation where he or she has to question these people closely about whether they did something that they were perfectly free to do, and putting them on the spot about and whether or not they had access to
we have the
information.
judge doing that with jurors all the time.
I understand that, but in this situation, these jurors had been discharged, and I think that it would be easier for the judicial system that once they're discharged, and they're certainly exercising their rights to access information, as opposed to an inquiry into whether a juror who engaged in wrongdoing is
There's no question that everything that you say would be preferable, but that's not the case we have here. And the question is whether what we do have here calls for a reversal. Are there any other questions for counsel? Thank you. Respondent?
May it please the court, Alexander Michaels on behalf of the people. In Brown, this court made clear that the formal act of excusing an alternate juror does not suddenly transform a qualified alternate into an unqualified one. Instead, the court considered functionally.
So obviously you don't think there should be a bright line rule. So if a person, is gone for 2 days and you call them and they say, oh, I haven't spoken with anyone, the court can just call them back. I mean, isn't that a slippery slope? And aren't we just sort of ignoring the realities to say that we can release someone beyond the court, beyond once? What does that word discharge mean? I mean, available. What does available really mean in these contexts?
I think it's important to keep in mind that this is all happening in the context of an ongoing trial. So if you're talking about an alternate juror...
No, it's not happening in the ongoing. The trial is happening in the building and the person has gone home. And it was within the context. I mean, there are ways, as I think counsel alluded to, that you wait until the jury has begun deliberations before you tell a juror your service is done, go, which is exactly what you're doing what the court is doing when the court discharges, is saying your service is done, go.
Well, I apologize, Your Honor. My point about the ongoing trial was about the timing of the situation. There's simply no way to excuse an alternate juror for multiple days while a trial is ongoing and not have the alternate juror miss some significant portion of the
So what if you adjourn? What if the jury discharges the court discharges the jurors? One of the jurors says, I'm not feeling well. The court says, we'll adjourn for a day and a half.
Well,
deliberations yet.
Yes, but that would set up the kind of outer bound that you're dealing with.
Well, that's one of the problems, isn't
But are
it?
we dealing with that
At
circumstance?
this kind of slippery slope where, you know, we are now having to make a determination as to whether it should be an hour or an hour and a half or a day or something different. I mean, what do the words discharge mean, and what do the words available mean?
Well, in People v. Brown, this court rejected the idea that the words "you are discharged," "you are excused" automatically transform a qualified alternate into an unqualified.
But the court did refer to the words de minimis. It did refer to de minimis or immediate retraction.
Well, just to be clear, in Brown, the retraction was not immediate. What happened in Brown,
but the court referred to an immediate retraction as the context of when this would be appropriate. An immediate retraction, I believe, was the language.
Sorry, I'm just glancing at the decision myself right now. I don't see the word immediate in here. There was a citation to another case involving an immediate retraction, but here the court called it in Brown. The court called it de minimis.
De minimis. Okay.
And I think the important thing to consider for the purposes of assessing what is de minimis is, functionally speaking, whether there's a realistic concern that this alternate juror has engaged in anything that would be problematic.
So, and the court then has to make a determination of the realities that this juror has faced once they've left the building?
Well, in this case, the court was absolutely able to give itself confidence that the alternate juror had in no way.
Counselor, let me stop you. Counselor, who is in the best position to make that determination? Is it the trial judge who's been through the trial, observing the jurors, or is it us sitting here on a cold record to determine whether or not the alternate jurors answered the questions asked as to whether they had any contact fairly and honestly?
The trial judge is absolutely.
Well, unfortunately, your answer to that question takes away our role in so many different instances. That's why we're here. We have a cold record most of the time. That's what we have to look at. Sometimes it's in being the 13th juror. Either way, the record is cold.
And how has the Court of Appeals looked at this provision in terms of trial courts applying this?
Well, my understanding is that 270.35, decisions made implementing 270.35 are generally reviewed for abuse of discretion. So yes, Your Honor, obviously this court does have a role in reviewing these issues, but I do think that there's something to the idea that these issues are reviewed for abuse of discretion at the appellate level rather than reviewed de novo. And I would just stress here that the trial court had ample reason to think that there was no concern about this juror's ability to continue serving.
And so, as I say, then it wouldn't be an abuse of discretion if you let someone go and they were home and doing whatever they were doing for a day and a half because you've adjourned the case for a day and a half. And they say, I haven't talked to anybody, I haven't interacted, there's nothing I've seen or heard that would influence me in this.
Well, I want to make clear, Your Honor, that is not this case, right? This case.
No, that's what this case potentially could be. You're saying the discretion, and it's the same circumstances, no deliberation. It's just a matter of time. If the time isn't de minimis, then and it can go on for an hour and a half, the person can actually get home. I mean, don't there have to be some boundaries? Don't we have to sort of figure it? You know, this just will lead to. Well, I've said it. It's a slippery slope.
As I said, Your Honor, it's not as though the court can adjourn the case indefinitely. It's not as though deliberations can be suspended indefinitely. There are rules about how long an adjournment or deliberation suspension can happen. And so those provide outer bounds here. And I want to stress.
This would become a fact-intensive determination.
Well, there are various relevant considerations that, yes, that a lower court can take into account in deciding whether an alternate juror is still available to serve fairly and impartially. And I want to stress that the interval of time here was essentially the court's lunch break, right? The alternate juror was missing for the court's lunch break, plus about 15 minutes as the parties were figuring out what to do about the juror.
So the fact that the juror has now traversed, you know, in an hour and a half, I could get upstate somewhere. So, you know, the fact that this juror has traversed however they came there, whether it's bus or train or whatever, and has ended up in a totally different place, in their home, that's irrelevant. The fact that they've gone it's only that an hour and a half is not an unreasonable amount of time. I mean, there have to be other factors that are being addressed. I still don't see that you've answered the question with regard to what available really means.
Well, other factors absolutely should be addressed here. And those other factors could be whether the juror had visited the site of the incident, which is a question that he was specifically asked, and he specifically said that he had not. Whether the
Seems
juror
like we're leaving a lot up to the jurors after they've already been told that they are no longer required to serve. And they're now not just out of the building, out of the courtroom, out of the context. There's something totally.
Well, this alternate juror was called back into court and was questioned at length by both the judge and the prosecutor to ascertain whether he had engaged in any communications that were remotely improper, to assess whether he had already formed an opinion on the issue. And his answers were very unequivocal and very steadfast. That obviously gave the court ample confidence to conclude that he could continue to serve fairly and impartially.
Any other questions? Thank you.
Thank you, Your Honors.
Appellant.
Your Honors, the question came up about the interpretation of 270-35 in the Court of Appeals. I want to stress that this issue has not been addressed yet by the Court of Appeals, that this is an open legal question for this court's review. The other thing I want to stress is that there was some discussion about, that you could let jurors go during an adjournment for a couple of days and bring them back and question them. But importantly, in any other situation, when jurors or alternate jurors are going home, before they leave the courthouse, the judge is required to instruct them. You may not discuss this case. You may not access information. That's how the legislature wants it to be dealt with if you're going to let jurors leave the courtroom. That did not happen here. These people were not put on notice that they had to restrict access.
Respectfully, counsel, wasn't it the role of the trial judge when the jurors were contacted to ask those questions, to ascertain whether or not they had contacted anybody or discussed the issues, et cetera, et cetera? And didn't that occur here in this case?
That occurred here.
Why is that sufficient?
Because this is something that is so fraught with risk in the modern society, with so much information out there, with people hardly able to not check their phones.
So in other words, essentially, you're suggesting that we should not, when jurors respond to trial court's questions, we shouldn't accept their answers as being truthful?
I think in this particular instance, if you look at the colloquy that occurred on the phone call that was in open court, the judge said to this alternate juror that another juror had violated her responsibilities, and they were calling to see about whether this juror could serve. So it's a very fraught situation that these alternate jurors feel on the spot. And I don't think under these circumstances, this is an appropriate inquiry for the judge to make. They've been discharged. They're perfectly at liberty to do whatever they want to do. And now you shouldn't be bringing them back after they've been home for an hour and a half and engaging.
So your rule would be essentially that if they're in the courthouse, maybe that's different. But once they leave the courthouse, they're completely disqualified.
I think that, there was
even if they live across the street from the courthouse.
There was some discussion before about Pearson, which is the case this court cited in Brown. That's a case where the question is, could you poll them if you discharged them? And the court talked about, well, they're still intact. They're still in the courtroom. That's my idea of de minimis, that the Pearson standard that this court referenced.
Any other questions? Any other questions for counsel? Thank you. Thank you both.
Thank you, Your Honor.
Tri-City versus New York City Taxi.
Good afternoon, Your Honors, and may it please the court. I'm Eric Shumsky, and I represent the appellants Tri-City and Endor. Your Honors, this is a classic case of an agency failing to.
But this is after all an Article 78 proceeding, and you have a very tough standard to overcome in seeking to set this aside. So how is it irrational or even not reasonable for the Taxi and Limousine Commission to adopt a standard saying that we're going to use an industry-wide utilization percentage? Because isn't it rational for the Taxi and Limousine Commission to say how it having an industry-wide utilization rate incentivize companies to have passengers in their drivers' vehicles?
Well, there are two problems with what the TLC did, Justice Friedman. First of all, it didn't consider the alternative, right? It didn't consider at all whether an industry-wide standard would be effective to accomplish the goals of the legislation. And that's something that—
And there was testimony, was there not? There were two economists who testified, Parrott and Reich, and they supported calculating a utilization rate based on a company-specific basis.
This is perhaps the most critical point in the case, Your Honor, and I can't emphasize this strongly enough. At no point did Parrott and Reich consider industry-wide utilization. The issue was put before the TLC, and neither Parrott and Reich nor the TLC itself at any point considered whether industry-wide utilization would serve the goals. But the second problem, and this goes back to Your Honor's first question, the second problem is that they actually failed to consider the potential harm to competition here. Right, this issue was raised, the concern was raised that there was a real danger here to the market. And at no point did the TLC consider
their primary concern, was it not, under the legislation calling for this, to see that the drivers received a living wage?
That's right, Your Honor. That is absolutely correct. And then the question is, under absolutely foundational principles of administrative law, were there alternatives that could also achieve that end, but without the downsides? Remember that the Court of Appeal—
Counselor, this is Judge Singh. What data did Lyft present on this issue, which TLC should have considered?
So I'd point, Your Honor, I'd like to answer the question in two ways. First of all, I'd point, Your Honor, to the comments that Lyft submitted and page 534 to 535 of the record, along with the economic appendices, laid these issues out. But I want to quibble just a tiny bit with Your Honor's formulation. Lyft didn't have an obligation to put data before the commission. Remember, this is notice and comment rulemaking. And so what an agency has an obligation to do is to use the words of the U.S. Supreme Court to consider an important part of the problem. And Lyft raised a very important problem here, and it's a problem that was so important that indeed the sponsor of the legislation, Council Member Lander, himself expressed very serious concerns about this, and that's at page 1574 of the appendix. And so you have these two fundamental problems that intersect with each other here. You have the concern being raised that using a company-specific standard would risk harm to the market, would risk causing this market to slide back toward monopoly, and you have the agency failing to consider responsible alternatives. And importantly, recall that the TLC on appeal here hasn't even disputed that that's something that an agency has to do. When you look at cases like Farmers Union from the DC Circuit or Schneider versus Ambach from the Third Department, an agency, and this is language from Schneider, an agency must, quote, demonstrate that it made a considered evaluation of the feasibility of alternative methods for achieving its goals. And nowhere did the TLC do that at all here. It's just a fundamental defect in the rulemaking that occurred.
Any other questions for counsel? Thank you.
May it please the court. My name is John Moore on behalf of the New York City Taxi and Limousine Commission.
So picking up on what counsel said, did you consider reasonable alternatives? And if you didn't consider reasonable alternatives, can your rulemaking be upheld?
So I think that the rulemaking can be upheld here on a couple of points. The first is that there's—
So you agree that you didn't consider reasonable alternatives?
No, I want to address that point also. Is that Lyft's supposedly reasonable alternative is an inferior means of achieving the goals that the TLC was trying to achieve. Remember, the primary goal of doing this is to ensure that drivers are earning that targeted minimum wage of $17.22 an hour after expenses have been deducted. The utilization rate meets that goal by ensuring that drivers are being compensated for times where they don't have a passenger.
Does the record show that part of the reason that Juno went into bankruptcy was this rule?
No, our record does not say that. The filing in the Juno bankruptcy case, that's one of their, I think, first day statement, they do cite this rule as a reason for going out of business, or for needing to declare bankruptcy, rather. But on that point, they do not specify the use of a company-specific utilization rate. They highlight only the fact that there's now a minimum pay rule in New York. Now, Lyft at this point isn't challenging the rationality or the existence of that rule in general. They're saying only that this one aspect of it was insufficiently considered, and that's not true. And it doesn't speak to any of the issues that are present in the Juno incident for Juno. Now, returning to the point about the utilization, about the need for a company-specific utilization rate, were it otherwise, were there an industry-wide rate put in place, drivers for companies who are driving, who have a less than average utilization rate would be earning less than the minimum wage per hour. They would also
get the fact that many of the drivers drive for more than one company. How does that figure into this rule?
So that figures in that ultimately comes down to a division of how that idle time is allocated. And so that's the process of an ongoing rulemaking on the part of the TLC, which has been somewhat postponed due to COVID. But that is ultimately accounted for in what is going to be how the utilization rate is calculated. So what you're looking at then is drivers for whatever percentage of their time for Uber, whatever percentage of Lyft, however that gets allocated. If Lyft has a below average utilization rate, for instance, then Lyft is permitted, under their argument, to pay their drivers less than the minimum wage per hour worked, which is contrary to the purpose of this rule, and they're permitted to pay their drivers less than their competition per hour worked, which Lyft itself seems to argue would be unfair with their 7-Eleven bodega comparison. So to say that rule, that their alternate argument, their alternate rule is rational, that the TLC had to abandon its own rule and adopt that rule instead, is not supported by case law. It's not supported by reason.
But their central point, as I understand, is that your rule will lead to diminished competition.
There's no evidence for that whatsoever. I would urge your honors to look at Lyft's comments, look at what they submitted in the record. All that they say is a serious concern, and the reason we know it's serious is because we said it was serious in the comments. They can't just say this is a serious concern and demand additional rulemaking as a result of that. They have to just put in something in the record to show that TLC's rule is irrational. They haven't done so beyond their own
sense. If I understand how this works, it's going to under this rule, it's going to cost Lyft more money to comply with your rule. Since they have less business than Uber already, their choice is only to raise the price, and as they raise the price, it diminishes the amount of business they have, which it benefits Uber to at some point just be the only company left in town.
So I have 2 points on that. First, this rule does not require Lyft to pay more than its competitors. It requires Lyft to pay the same amount per hour as its competitors. Otherwise, under their version, they would be paying less. Second, I dispute the idea that they're going to necessarily have to raise rates on customers as a result, even if that were the case, even assuming they had to pay their drivers more, that would not necessarily result in rates being increased. They could take a lesser commission. As it is, they take the largest in the industry. So they have options available that don't necessarily lead to Uber being able to completely undercut them and drive them out of the marketplace. There's no evidence that that will happen. There's no
what is the standard of review here in resolving this for us?
The standard of review is there a rational basis in the record for the TLC's determination?
Any other questions for counsel? Thank you.
Thank you.
Mr. Shumsky?
Thank you, Your Honor. If I could just make 2 points. I'd like to start with the question that you asked my friend on the other side at the outset, whether the TLC considered industry-wide utilization. It did not. There is nowhere in the record that the TLC did that. Now, what my friend on the other side says is that industry-wide utilization, and these were his exact words, would be an inferior means of achieving the goal. And there are 2 fundamental problems with that. First, The TLC, the agency itself, didn't consider this. This is attorney argument.
Explain this to me if they used an industry-wide standard, how does that help to see that, for instance, Lyft drivers are getting paid enough to have this living wage that they were seeking to see get established? How does an industry-wide standard accomplish that?
Because if you're using an industry-wide standard, each of the companies still has an incentive to increase its utilization, because by increasing their utilization, you will also increase the industry-wide standard. But I also want to point out, Your Honor,
but you have much more of an incentive if you're using a company-specific standard.
So, Your Honor, the problem is two things. First, we don't know whether that's true. We can sort of do armchair economics and speculate about it. But the fundamental point is that the agency didn't determine that that's true. At no point did the TLC actually analyze this question. And contrary to what the agency is now saying on appeal, when they argue that it's an inferior means of achieving the goal, the TLC itself has put an industry-wide standard into place.
Isn't it sort of readily apparent that if you're using a company-specific standard, there's much more of an incentive for that company to raise its utilization for its drivers than if you're using an industry-wide standard?
There might well be, Your Honor, but that gets back to the basic
Is
problem.
that something you really need to have a formalized consideration of? Isn't that sort of just like a logical flow of this?
So, Your Honor, 2 points, and I want to try and get them both out because these are both critical. Recall that the agency put in place an industry-wide standard. So while on the one hand, they're standing before you here today and saying an industry-wide standard is so inferior that we could never use that would never accomplish the goals of the regulation. An industry-wide standard has been in place for 22 months. An agency cannot talk out of both sides of its mouth that way. But, Your Honor, even if we were going to sort of engage in this form of armchair economics and say company-specific could be more effective than industry-wide, that still leaves the problem that the agency failed to consider the potential harm to competition. Even if you assume it to be true that company-specific utilization might be more effective, that still leaves the wholly unaddressed problem about the harm to competition. And that was a serious concern. The TLC is saying that the submissions, that the comments were not significant enough to make that point. But again, we have the very sponsor of the legislation, Councilmember Lander, saying that this is such a serious concern that he has grave worries about it.
Counsel, please finish up.
Thank you, Your Honor. We would simply say these are not onerous obligations on the agency. This is a billion-dollar market affecting tens of thousands of drivers and nearly 250 million rides. And it is not too much to ask the agency to go through this form of analysis before it regulates. We'd ask you to vacate the rule.
Any other questions for counsel? Thank you. Thank you both. People versus White.
Yes. Good afternoon, Your Honors. I may please the court, John Vang for Derek White. Your Honors, in this case, the police denied Mr. White his right to counsel at the lineup. The right to counsel attached here in this case. Mr. White invoked his right to counsel, and in response, the detective understood that to be a request for counsel at the lineup. Now, the detective's understanding is an important component here, and that's where the lower court erred. The court completely divorced the detective's understanding from the analysis, but the detective.
What did actually the defendant say with respect to having counsel?
So he said, "I have an attorney," and if we look at that on its own, in a vacuum, it may seem that that's not enough. But we have to look at that in the totality of the circumstances. Not only did he tell him that he had an attorney, he then gave the detective the name of the public defender's office where his attorney worked.
An attorney on another case, correct?
I'm sorry?
Was an attorney on another case?
It was an attorney on another case, right. But the rule is that if it's an attorney in another case, the defendant has to request that attorney in this specific case, and he did that under the circumstances. And in response to giving the name of the public defender office, the detective then went and actually looked for the telephone number and got the telephone number of that public defender office. Now, what the court got wrong here is that the court completely divorced the detective's understanding here. The detective understood that that request should cover the lineup, but it seemed that the court wanted Mr. White to utter specific words, but that's not the law. The Court of Appeals ruled in People v. Mitchell that, quote, no magic words are required. Instead, and this is the important part, the invocation only needs to, quote, alert the police that counsel's present at the lineup is specifically requested. That was satisfied here. The detective
I'm sorry, I'm missing something. How was that satisfied here?
Well, the detective wasn't understanding. No, sure. The detective understood. He said that he understood that the attorney should appear at the lineup. After Mr. White told him that he had an attorney, and then after Mr. White gave him the name of the public defender's office where he worked, that was the invocation. And the court seemed to think that he had to specifically utter, I want my lawyer at the lineup. But the Court of Appeals has made clear in Mitchell that's not required. There are no magic words required. It only needs to be an invocation that alerts the police, as they did here, that counsel's presence at the lineup is specifically requested. And that was satisfied here. You know, the lower court.
If I may, counsel, this is Justice Kennedy, but the defendant indicated that he had an attorney on another case. It wasn't this case.
Right. But the rule, but Mitchell says that if it's, you can have an attorney in another case, and in order to invoke that counsel's right to presence in this case, you need to, request counsel. Under the circumstances, there needs to be an unequivocal invocation of counsel in this case. And that's what he did. That's what happened here, and that's what was satisfied. And the lower court disregarded all of the circumstances. The court seemed to look at Mr. White's statements in a vacuum. It ignored the fact that Mr. White had given him the name of the public defender's office, and the court ignored the fact that the detective then went to look up the telephone number online. And this is the important part, which, again, the court completely divorced from the analysis. The detective understood that request was a request for counsel at the lineup. We can't just ignore what the detective understood. It's not only a part of the analysis, but it's why, as a matter of law, the right to counsel attached here.
And I just have to ask, so this was part of obviously the police investigation. Sure. Would they have had to have waited 2 days, 3 days, whatever it was, before the attorney got back to them? They would not be able to go ahead with the lineup?
Absolutely not at all, Your Honor. The only requirement here is a reasonable opportunity to appear, and that actually wasn't decided adversely to us. I think the court acknowledged that this wasn't a reasonable notice. That was actually what the court acknowledged. And there was no showing of exigency here. There was no showing of any need to, expedite Mr. White's arrest. None of that was present here. And again, the court acknowledged that, except that the court seemed to think that the right to counsel didn't attach here because Mr. White, again, didn't utter specific words. But again, the court wrongly divorced what I think is the most important thing here, which is the detective's understanding that he wanted his counsel present at the lineup. That's squarely within People v. Mitchell, which is the Court of Appeals case that applies here, which is that once the police have been alerted that the defendant wants his counsel present at the lineup, the police need to make reasonable accommodations to make sure.
Counsel, any other questions for counsel? Thank you.
Good afternoon. May it please the court. This is Vincent Rebelisi for the respondent. I think that with the lineup, the detective made a mistake here, and he thought that he had a duty that he didn't have. And when the detective did that, the efforts that he made, if he had that duty, might not have been sufficient. And the trial court did say that. So the question isn't whether the detective made sufficient efforts. If the detective had been required to give an opportunity to the attorney to appear, that wouldn't have been enough. But the question here is what the trial judge found is that there was no unequivocal invocation of the right. What the defendant did here is that when he was asked whether he wanted to speak to the police, he said he had an attorney in another case. But he didn't know at that time that there was going to be a lineup. It hadn't been discussed yet. And that lineup came up later. When the lineup came up later, there was no discussion at all about whether the defendant wanted his attorney for the lineup. The detective just happened to think he was supposed to notify the attorney.
So
he
you're
tried, but he
saying
didn't
you're
try that
saying
hard.
that
And
you're saying
if he had been
you're
required,
saying
we're not saying that that was enough.
the defendant, the accused, has to come in and be able to articulate every aspect of the law that they need the attorney to represent them at every stage. So in other words, it wasn't enough to come in and say, I have an attorney. I don't want to speak with you. He had to say, I have an attorney. I don't want to speak with you. I don't want to be in a lineup. I don't want to have a suppression, a hearing. I don't want to. Is that what?
Well, the thing is, you don't have a right not to be in a lineup. So it's a separate right that you'd be requesting an attorney for. He didn't have an attorney in this case. This is an attorney in a different case. When they were asking whether he wanted to speak to the police, and before there was any mention of a lineup, he said, I have an attorney. But speaking to the police is something where you are giving up your right to incriminate yourself, or not to incriminate yourself. And the Court of Appeals has said that's a different type of protection than just the passive participation in a lineup that you can't stop even if you are represented. It's a different thing that you have a concern about. So when you're speaking to the police, it's a much more intrusive and invasive thing. They're being exact language that it says is, well, no magic words are required. I'm quoting, an unequivocal invocation must alert the police that the presence of counsel at the lineup is specifically requested. And this court said in Rios, also cited in the brief, defendant's statement that he would not speak with the detective and that he had an attorney did not trigger right to counsel at the investigatory lineup. So it's really exactly the same here. There was no discussion at the time of the lineup about the counsel. So he didn't have the right at that point, and the detective wasn't required to get the attorney or give the attorney an opportunity to appear at all. He just tried a little bit. He didn't try enough. That's the only question there.
Any other questions for counsel? Thank you. Mr. Dang?
Yeah, sure. I mean, I'll just respond to the point that my adversary made, that this was a mistaken understanding. You know, that was not the basis for the court's ruling below. The court did not rule below that the detective had a mistaken understanding of what this request meant. So that's not really an issue that's up for review on this appeal. But my adversary said that.
Counsel correct that asking for the right to having a counsel at the lineup is different than what attaches with regard to statements and speaking to
sure.
At the time you're making statements. So he asked for that specifically, but one doesn't necessarily have to have an attorney at a lineup.
That's true. One doesn't have to have an attorney at a lineup.
Request.
But in Mitchell, Mitchell acknowledges that when a defendant is in custody and already represented by counsel on a related case, he can invoke the right to counsel at a lineup by requesting his or her attorney. And in examining whether or not he invoked his right to counsel in this case, you look at the totality of the circumstances. You look at what he said, what he did in this case, and specifically, you also look at what the detective understood in this case. The detective understood in this case that he wanted to have his lawyer present at the lineup. That is a crucial fact that the court disregarded. That is a crucial fact that places this within Mitchell. The police here were alerted that Mr. White wanted his lawyer present at the lineup. So in that circumstance, the right attached. There was no need for him to make successive requests at the lineup. I mean, he already made his request for counsel once at the outset. The detective said that, I wasn't going to call counsel anyway, until the lineup was already assembled. But we know that was too late. I think disregarding the fact that the detective understood this to be a request for counsel seems to elevate form over substance in this case.
Any other questions for counsel? Thank you. Thank you both. Awad versus Fordham.
Good afternoon, Your Honors. May it please the court. My name is James Ryan of the law firm of Cullen and Dyckman, attorneys for Appellant Fordham University. As this court has seen from the many briefs of the amici and the respondents, my learned colleagues have raised a number of numerous, diverse, and very complicated issues, such as Title VI of the Civil Rights Act, First Amendment rights, free speech, geopolitical matters involving the Palestinian and Israeli conflict, state and federal denunciation of boycott, divestment, and sanctions against Israel, as well as a discussion of BDS. Those issues are extremely important. They're very passionate, they're very genuine, and as I said earlier, they're very complicated. This case, however, involves none of those issues. This case simply involves a proposed student club to be funded, supported, and approved by a private university.
How does the First Amendment interplay with Fordham, which is a private entity, right? It's not a government entity.
Correct, Your Honor. And Fordham, through its mission statement, permits students to express their views. This case, however, has nothing to do with First Amendment issues. This case, however, simply deals with a proposed student club to be funded, supported, and approved by a private university. The name of the proposed club could have been anything. The purpose of the club could have been anything. The way the club is approved is the same for every club. Therefore, the issues before this court and the TLC case immediately prior was very insightful. The issues are very simple. Did Fordham comply with its internal policies and procedures? It did. And was there a rational basis for Dean Keith Eldridge, who was charged with determining whether to approve a proposed club? Did he have a rational basis to deny the respondents, Students for Justice in Palestine's application for a student club at Lincoln Center? The answer to this question is also yes. As seen in the student club guidelines.
Excuse me, Mr. Ryan, I was on mute. This is Justice Kennedy. What were the steps that the dean took in reaching his determination?
Your Honor, the steps were quite extensive, and they are produced at pages 64 to 175 and 459 to 469, among others, of the record. But and as set forth in his detailed affidavits, as well as Dr. Wenzel's affidavits and the supporting exhibits, he did extensive research. He met with the respondents and supporters, and he reviewed voluminous materials submitted by everyone. He conducted his own independent research and extensive research into SJP. He interviewed a number of people at Fordham with knowledge of Middle Eastern issues as well as SJP, and he met with numerous Fordham constituencies. He did all of this over a span of weeks. This was not a decision he made in a matter of minutes or hours. This took over a month. And that research showed that similar SJP chapters regularly disrupted and interfered with students and campus operations. It also showed that the promotion of BDS was the cause of many of the safety and security issues associated with other SJP chapters on other campuses. After that extensive review, the dean sent the respondents a 3-paragraph email in which he summarized his reasons for denying the approval. He then vetoed it. But the record, Your Honor, is clear. The dean clearly had the power to veto the application for a student club to be funded and supported by Fordham University, and he clearly had a rational basis for doing so. And he exercises our honest discretion in making his decision.
Thank you. Any questions for counsel? Thank you, Mr. Ryan. Respondent?
Alan Levine for respondent students. Counsel correctly says all of those issues about Palestine and Israel and those complicated policy issues are not before the court. What's before the court is not similar chapters at any other college. What's before the court is the behavior, the promises of the 5 students who sought to create a club simply to promote understanding about Palestinian rights. It is true, as my colleague says, they were investigated for a year. They were interviewed by deans. They submitted many materials. The dean said, give us an amendment to your constitution that says you will be independent of all other chapters of SJP and the national SJP. They amended their constitution. The deans had no reason whatsoever, and there is no evidence whatsoever to suggest that that promise of independence was not truthful, none whatsoever. The United Student Government said this SJP will make an important contribution to diversity and understanding at Fordham, and there's nothing that Dean Eldridge found that would pass that conclusion into the students here promised to create a club that would be, as Justice Bannon found, would be nonviolent and would pursue their goals of education about Palestinian rights. They then, pursuant to Justice Bannon's order, operated for a year or so and fulfilled that promise. There's nothing in their behavior during that time that would hint that they were going to engage in any of the conduct that supposedly concerned the dean. It's also important, as we note, to remember that the dean, after his investigation, after reading all these materials, said nothing about safety and security or behavior of similar SJPs at other campuses. He said simply that this would polarize the community and that these students were concerned with only one country. Justice Bannon made light of those reasons, and appropriately. And the idea that Fordham really means that it does not allow speech that is polarizing is certainly inconsistent with their invitations to Karl Rove and Newt Gingrich. And they certainly did not apply that to this.
This is Judge Singh. Is there anything stopping students who want to protest, who want to push the BDS movement from doing so on the campus?
Well, there are some things that you can't do if you're not an official club. That number one. But number two, Fordham recognizes that official clubs do have a particular status. They are allowed to solicit students. They use facilities. They can get Fordham funds. So the denial of official recognition has real consequences to the petitioners. And it's perfectly clear from the record in this case, Your Honor, that all this is about the controversy surrounding Israel and Palestine. And one understands Fordham's reluctance to stir that hornet's nest. But avoiding controversy is not a ground consistent with its mission statement. It's promised to students that they will have the right.
But can it be said? Can it really be said that the dean's veto here was not an exercise of honest discretion? I mean, we've heard what was done. He considered the facts. Maybe he got them wrong. I don't know. I take no position on that. But how do we get behind that decision of the dean? Because the dean has the right to veto a club.
Yes, he does. And like administrators of any corporate entity covered by Article 78, he has to exercise his discretion.
How is it not? You disagree with the decision. How was it not an exercise of honest discretion? If he hadn't considered anything, that might be an example of no discretion at all. But in this case, he did consider it.
Yes, he did. He did. And he examined the students and their papers for the better part of a year. The United Student Government said this will be a terrific club for Fordham. And all he said in writing his letter is, this is going to be polarizing. Well, The question is that...
But he said more than that. He says it's contrary to the mission and values of Fordham. It disrupts open dialogue and mutual learning. We're not going to question those decisions, right?
Well, I'm not sure why, Your Honor. It seems to me that at the least he has to have some evidence for believing that these students will disrupt anybody at Fordham, and there's no evidence whatsoever.
Any further questions for counsel?
I do have one more question. Going back to the issue of standing, how is that made out here? The students have now graduated?
Right, and so one...
Shetty, at the time, what was Shetty's status at the time this controversy was going on?
He became a student in the course of the litigation. He was affected by Dean
after the decision or before the decision?
Before the decision. And so he had already become a petitioner by the time of Justice Bannon's decision. And he was a student. But not at the time of the dean's decision. He wasn't a party to it then. That's the truth. But like every other student at Fordham, he was bound by that decision. No student could form a Students for Justice in Palestine at Fordham pursuant to that decision. So
there's nothing to stop him from going back and trying again.
Well, yes, but the law doesn't require that he do those kinds of futile acts because he would be denied. Just as
Thank you both. People versus Wolf.
Yes, good afternoon, Your Honors. Taylor Bonner for the appellant, Mr. Cedric Wolf. May it please the court. The main issue in this case is whether or not Officer Bach suspected that Mr. Wolf was armed or posed a risk to his safety upon deciding to frisk him. We know from the hearing testimony that he did not. If I may, I'd like to point out some pertinent moments from the hearing. On page 22 of the hearing transcript, the officer said that he asked Mr. Wolf to get out of the car so he could make a determination as to whether or not Mr. Wolf was intoxicated. Later, on page 48, in response to defense counsel's questioning about whether he saw any indication that Mr. Wolf was armed, the officer repeatedly answered in the negative. When specifically asked if he observed anything that led him to believe that Mr. Wolf was armed, the officer simply said no. And significantly, on page 50, when asked if he ever felt anything during the pat-down that he believed to be a weapon, the officer also said no. So based on the officer's testimony, we know that he did not hold the belief that Mr. Wolf was armed or posed a risk to his safety, as is required under DeBoer to justify a protective pat-down. The frisk was therefore unauthorized, and the subsequently seized evidence should have been suppressed. In regards to the appeal waiver, the court's explanation was very confusing, and that imprecision was not cured by the written waiver. The court inaccurately and heavily implied that the right to appeal only applies when a defendant goes to trial. In fact, while she said that the right to appeal is separate and distinct from the trial rights that are forfeited, that statement was followed up by an explanation that if Mr. Wolf had taken his case to trial, he would have had the opportunity to appeal any of the court's decisions. Mr. Wolf was never told that a defendant typically retains the right to appeal even when entering a guilty plea, and he was not told that the waiver was a special condition of his plea.
Counsel,
furthermore,
I'm sorry, counsel, why doesn't the written waiver have any impact on our decision here?
So there were never any on the record acknowledgments that Mr. Wolf read or discussed the written waiver with his attorney. The court only asked, he did sign it. However, if you look at the way the proceeding went, defense counsel received the written waiver, and then shortly thereafter, the court was asking Mr. Wolf, oh, did you sign the waiver? And this, again, followed the confusing oral colloquy wherein she said that if he'd taken his case to trial, then he could appeal. So Mr. Wolf never really understood the waiver through the oral colloquy, and then never really, at least from the way it's written in the record, seemed to have an opportunity to discuss the written waiver with his attorney.
Any other questions for counsel? Thank you.
Thank you.
Good afternoon. May it please the court. Claire Nielsen for the people. First, Your Honors, defendant executed an adequate waiver of appeal, and thus the court need not reach his additional arguments. However, we ask the court to affirm nonetheless. The court's suppression ruling was proper. After the officers approached the car, they saw marijuana and alcohol in the car in the front seat, and at that time, they had every right to ask defendant to step out of the car and to frisk him. In actuality, the officers could have searched the car and the occupants once they saw those items in the car, according to People v. Chapman, but the officers chose to frisk the defendant instead, which was even less of an intrusion, and thus the officers acted more than reasonably in this situation. Additionally, if you look at the totality of the circumstances, the officers reasonably conducted a protective frisk for their safety due to several factors. It was late at night, they were in a remote area just off the exit ramp of the highway, and defendant had been drinking and driving with illegal substances in the car. And it was also a reasonable measure for the officers to heighten that frisk by holding defendant's hands on the roof of the car. Truly, it was defendant who acted unreasonably by interfering with the officer's ability to conduct the frisk. He continuously disregarded the officer's simple instructions by moving his arms to his waist. And again, the officer's actions were completely reasonable under the circumstances.
Any questions for counsel? Thank you. Thank you both.
Thank you.
Vector Media versus Golden Touch.
Yes, good afternoon, Your Honor. William Gary for the defendant, appellant Golden Touch. The lower court's decision in this case is flawed and should be reversed. First, the lower court mistakenly read into the advertising agreement a provision that the parties did not agree to. Second, the lower court disregarded the fact that the plaintiff failed to perform the obligations it was required under the Wi-Fi agreement to fix its defective boxes.
Counsel,
the lower court,
counsel.
Yes, Your Honor.
Yeah. You, with regard to the lease with your lease with the Port Authority, your client's lease with the Port Authority, that came about when your client discontinued the lease. Is that right?
Yes, my client.
They terminated the lease with the Port Authority. Is that right?
Correct, Your Honor.
Is that the reading? Is that a proper reading of 13A? Was it meant for the defendant, the client, to terminate, or was it expecting that there would be circumstances where the Port Authority might discontinue bus service or have to discontinue the lease, but precipitated by the Port Authority, not by Golden Touch?
Well, Your Honor, you're going to the issue of whether or not there was a condition precedent that first had to be met. And in order for Golden Touch to terminate the advertising agreement, that happens when they find out and they correct, in essence, a mistake, and they add that language into the Wi-Fi agreement. There is it's an unconditional right, because it speaks both ways. It is an or in the provision of the contract itself. So my client, Golden Touch, had the right to terminate the contract.
Wouldn't that would mean that they could terminate the contract anytime they wanted to?
That's correct, Your Honor.
That's not what it says in the contract. That's not the understanding. Otherwise, it would say for any reason. It doesn't. There's nothing like that.
But Your Honor, you're asking that the contract that's drafted by the plaintiff, all right, that it should have that language in there. That limiting language, that restrictive language, is not in the contract. So they had the unconditional right to terminate the contract.
I'm sorry, counsel, I don't understand. I'm sorry, go ahead.
I was just going to say, isn't this in violation of the doctrine of prevention, where your client is voluntarily disabling itself from being able to comply with its own contractual obligations? They're creating the circumstance.
They're not, Your Honor. They're not creating the circumstances. The prevention doctrine doesn't apply because the prevention document has that there is a condition that needs to be met first. There was no condition that had to be met here in order to terminate the contract.
Yeah, but just look at the plain language of the contract. In the event that licensor's right to operate the business is terminated, it doesn't say for any reason. It just says it's terminated, i.e., if the Port Authority terminates the license, then it's over. Isn't that the plain meaning of this language?
I don't believe so, Your Honor, because if you look at the language itself, the court tried to put in there that there was an act that had to be taken by the Port Authority in order for this to come into being. So they're bringing in a third party to the contract, which wasn't the understanding of the parties. There was an understanding of the parties that the contract speaks for itself and that the transportation company had the right to terminate it, regardless of whether or not they terminated.
I'm sorry, where does it say that? Where does it say that? I might be missing it in the language. Where do you say it says that?
If you may, Your Honor, I'll go to it right now. On the record, in going to section 13A of the early termination clause, on the record on page 74, all right? In the event the licensor right to operate the business is terminated, or the
Where does it say it has the right to terminate the license?
Excuse me, Your Honor?
Where does it say that your client has a right to terminate the license?
My client's right to terminate the license with the Port Authority is in the Port Authority agreement, Your Honor. So they exercised their right under the Port Authority agreement, which then they were no longer providing services to the Port Authority. So they had the right to do that. If the plaintiff wanted to curtail that right, they should have done so like they did in the Wi-Fi agreement. In the Wi-Fi agreement, they curtailed my client's right to exercise its unfettered right to terminate the agreement. Because in that agreement, in section 7 of that agreement, they put that language in. So they realized that I don't want to say a mistake, but they realized that there's an issue, and they addressed that issue in the Wi-Fi agreement. So therefore, they corrected their mistake. So therefore, there was no restriction, no limiting language in the agreement for them to exercise. And the plain language of the agreement in and of itself says that. And also, if I may just address, because I have a limited time, the Wi-Fi agreement. There was proof presented to the court that there were issues with the Wi-Fi agreement. That alone justified a denial of summary judgment. There was testimony presented or proof presented that there was issues that the boxes did not work. My client isn't a bus company. They're not in the business of maintaining and fixing Wi-Fi boxes. And the novel approach by the plaintiff to fix the problem is pay us $24,000 and we'll put in new boxes. Well, that was
there any question about the voltage that the system needed to work properly?
Yes, there was, Your Honor. And
was there sufficient voltage? Mm-hmm.
But Your Honor, but going back to what I was saying earlier, we're a bus company. When they came to us to put the Wi-Fi boxes in the buses, why would it be incumbent upon us to say to them, okay, fine, put the Wi-Fi in. Okay, but we are guaranteeing you the voltage of the bus. That was not the requirement. Our client didn't have to make a representation that the buses had sufficient voltage or electrical service to operate or maintain the Wi-Fi boxes. That was their responsibility. They're the experts. We're not the experts. We have buses. We run buses. We don't fix and maintain Wi-Fi boxes. We're not a network. We're not an internet service company. And that was their responsibility to do. And if there was a problem with that, they were required to correct it, which they failed to do.
Any other questions for counsel? Thank you. Respondent.
Thank you, Your Honor. Respectfully, the decision below is proper in all respects. Taking the first issue at hand under the advertising agreement, it's quite clear that there is no right that the appellant had to ultimately terminate this agreement.
But how do you respond to counsel's argument that when you look at the Wi-Fi agreement, which is much more specific, that somehow suggests that there is a right to unilateral action by the bus company?
Two responses there, Your Honor. One, it's over a year later, I believe, so it's not this type of situation where you can read the documents together as a harmonized, cohesive doctrine. Secondly, Your Honor, that's just making clear what was already clear. My client shouldn't be punished for taking additional steps to make it even clearer that they can only get out of this when their agreement is terminated with other parties. That doesn't mean in any shape, form, or fashion that the original language is ambiguous in the advertising agreement. And that's doubly true because, as Your Honors appreciated, this is a 5-year contract. And under the appellant's argument, it would mean that at any given time, they could just rip up the agreement and walk away, meaning they could sign a 5-year.
But not as to the Wi-Fi agreement. I mean, isn't there an issue of fact as to the Wi-Fi agreement, whether you furnished the material that you were supposed to furnish under the Wi-Fi agreement, and whether you did necessary maintenance to keep the bus's Wi-Fi running?
Your Honor, we don't believe there's any factual issue there. The issue is the termination of that agreement. They had exited the business. They had left the business. They'd given up their license. That contract was therefore improperly terminated.
If your non-compliance caused them to leave the Wi-Fi agreement, wouldn't that leave an issue of fact?
No, it wouldn't, Your Honor, for the simple reason that there was actually never even a counterclaim asserted on that point. I don't believe that appropriately addressed that as a basis for why the agreement was terminated.
It's a appeal from a grant of summary judgment to you on that agreement.
Correct, Your Honor. They granted summary judgment because there was no opposition. Their basis for terminating was clearly stated. I also think that the record is clear that there was no breach of any obligation here. The obligation.
That's not accurate. That's not accurate. There, as my colleague pointed out, there were issues with voltage, and also, my recollection, there were issues with respect to priority. Aren't those issues a fact for a trial?
I don't believe they are, Your Honor, because the issue is a simple one, and it is: did they have the right to terminate that agreement?
Well, did you provide defective equipment?
Your Honor, but the basis for terminating the agreement, I don't believe that's the case, but even if that were true, the basis for terminating the agreement was that they were getting out of the business. So I don't believe that there's even a material breach there in that context. It's something that is in the wind. It's completely ineffectual because at the end of the day, the agreement is terminated because they surrendered their license. Whether or not there's material that's left over, there's no factual issue there. The instance in which they terminate the agreement by surrendering their license, they have anticipatorily breached the agreement, and that's the end of it. There are no damages that are alleged as a result of these boxes. It isn't a material breach which would justify terminating the agreement. It is at most a minor incidental issue which in no way would justify their ability to terminate the agreement. They plainly did not have the ability to terminate on the basis of any allegedly defective equipment, and the stated basis for getting out of the agreement is plainly insufficient because they didn't have the right to terminate the agreement merely because they wanted to exit the business.
Any other questions? Thank you. Thank you both.
Thank you.
Thank you.
Clark versus Empire General.
May it please the court, Nicholas Herzler for Empire, the appellant. Your Honors, I want to make clear that what our argument here is one of scope. So the plaintiff's, what he was hired to do, when he was hired to clean up and carry cement and that kind of thing. He was not hired to work on a scaffold. He wasn't trained on it. And the plaintiff, as the movement for summary judgment, had the burden of proof to show that this was within the scope of his work. And what does plaintiff rely on? This is very important. At page 498 of the record, the plaintiff relies on testimony saying that he went into the site on the day of the accident that morning and he spoke to Eamon Fallon, his boss, and Fallon told him to dismantle the scaffold, and that was the first thing I did. He says that.
Well, the plaintiff testifies, does he not, that Fallon told him to take down the scaffold. Fallon counters by saying that Gallagher told him
exactly, Your Honor,
that Gallagher told Fallon that he specifically told the plaintiff not to do that. But isn't that hearsay, and isn't that the only thing you have to oppose the motion? Yes.
No.
We're not hearing you.
Fallon's testimony.
Mr. Herzler, we're not hearing you.
Hello? Can you hear me now?
Now we could.
Can you hear me now?
Yes.
Can you hear me now?
Yes.
Okay. Can you hear me better? Is that better?
Yes.
Okay. What I'm trying to it's not Gallagher that we are only relying on. Okay. We also got the fact that Fallon testified he wasn't even on the site that day. Look at 903 of the record. He says he was in Yonkers that day. He wasn't on the site. Plaintiff comes in and says, I spoke to Fallon. He told me to go to take the scaffold down. Fallon says I wasn't even there. I heard about what happened because of later on I went to the hospital and I heard a story from Gallagher and King about what happened. So it doesn't, we don't even need Gallagher's hearsay statement. I think it's corroborated by other statements in the record, by the fact that the plaintiff wasn't trained on this type of equipment. He wasn't supposed to. According to Fallon, he said that plaintiff had no reason to stand on a plank or platform at 928. He said plaintiff had no reason to wear a harness at 987. He disobeyed instructions at 921. It's the fact that he said Gallagher was the only competent person. Gallagher was the person who had the OSHA training to take care of this. Plaintiff, again, he was hired to clean up cement and carry cement and that type of thing. It makes no sense. So whether you characterize it as Gallagher having a hearsay statement that's corroborated by other evidence sufficient to raise a question of fact, although hearsay, or whether you characterize it as the fact that Fallon simply disagrees, his testimony is in direct conflict with plaintiff's version. Because again, plaintiff said that he was told by Fallon to do this, and Fallon says I wasn't even there. So how is that even possible? It's a classic question of fact as to whether this was within the scope of the plaintiff's work duties. It's the same issue with respect to 240 and 241.6. And I mean, we can go through the testimony which we laid out in our brief, but at the end of the day, there's a classic question of fact there on the scope defense. I want to also talk about the grave injury issue with respect to the other party, Law Fallon, that got out on summary judgment arguing that there's no grave injury because it's possible that the plaintiff can work. This is a big record. There's a lot of evidence in it, and a lot of the evidence shows
So how do you
what the plaintiff is claiming and being clear.
How is an issue of fact raised as to grave injury?
So, first of all, you've got Dr. House-Connect's reports, okay, which are talked about in the lower court and in the Law Fallon's brief, okay? If you look at, for example, look at 2153 of the record. Dr. House-Connect, who's the plaintiff's treating doctor, he says, as of October 2018, plaintiff, quote, has been unable to work, end quote, due to memory problems, anxiety, insomnia, because of this head injury, okay? Law Fallon says, well, that's not good enough because, you know, he doesn't have a more recent report. Well, Dr. House-Connect has a March 2019 report. Look at 2184 to 2188 of the record, that's fairly recent. Talking about plaintiff had the symptoms for the past 4 years. He's got permanent problems. He's got comprehension difficulty, anxiety. He says at 2188, quote, temporary total disability, and I have advised him to restrict his activities. That's in addition to all these other doctors like Busicchio, Brown. We've got Dr. Sparadio. If you look at Law Fallon, they're saying, hey, we've got some IME doctors who think he can work. They have 4 IME doctors. They have 2 workers' comp doctors and 2 other IME doctors. And they say, well, according to our IME doctors, he can work. But that completely excludes all the plaintiff's evidence and the plaintiff's testimony and his girlfriend's testimony. What about the fact that Tiffany McKinney has been living with this plaintiff for years and says at 1854 of the record, do you know what prevents him from working? Answer, his brain injury. He talked about he has cognitive issues. He's probably not going to be able to go back to work. That's at 1854. I could go on and on, but the plaintiff, according to Law Fallon, none of this matters because, well, he's a lazy guy. He likes to hang out at home and play video games and that kind of thing. He doesn't want to work. Maybe, that might be a good argument for a jury, but they're moving for summary judgment here. Isn't it the case that we have lay testimony from the girlfriend? We have lay testimony from the plaintiff. Plaintiff, by the way, at 467 says he hasn't worked since the date of the accident itself. I mean, that by itself, just him saying, I haven't worked since the day of the accident. And in the lower part, when this went during oral argument, this plaintiff's attorney was asked, hey, are you claiming that, that your client cannot work permanently? And the answer from counsel was yes. And they're claiming that in the bill of particulars. So if the plaintiff is claiming that this person cannot work, and they have doctors that say that this person cannot work, I get that they have IME doctors who say something else, but that's a classic question of fact as to whether this person is permanently unable to work because of a brain injury. I'm not saying that he can't. I'm not saying that they're going to prevail on it, but I'm saying it's a question of fact.
Any other questions? Any other questions?
Basically.
Thank you, Mr. Herzler.
Thank you for listening.
I think I'm next. Thank you, Your Honor. Alani Golansky for the plaintiff. Empire's story keeps changing. Their defense keeps changing. Now, counsel.
So what about
that,
this point? So you rely on the fact that the plaintiff says Fallon told him to take down the scaffold, but now they're saying not only is the variant story of Fallon's conversation with Gallagher, but that Fallon wasn't even there. So how could he have told this to plaintiff? And that sets up an issue of fact.
Yes, I was just going to address that. Fallon was not there at the time of the accident. Neither was Gallagher there at the time of the accident. And Gallagher is supposed to be the hearsay declarant. The point is that Fallon was there earlier in the day. And the testimony was that Fallon, who himself said and testified that Rohan Clark always followed instructions. And Rohan Clark said that Fallon told me to take down the scaffolding. This is a small group.
So do you have a page reference to the record where Fallon is there earlier in the day?
Yeah, well, that's all throughout, our statement of facts. And I probably don't have it right off the top of my head right now, but it's in our statement of facts.
Okay.
He was there, he left. Gallagher was there, he left as well. It's very clear. Now, Fallon testified, he was asked, does it make sense to you that on the day of the accident, and this is at page 904 in the record, that Low Allen masons and laborers, that is Rohan Clark, were involved in continuing to construct the elevator shaft on that day? And Fallon says yes. It's only at the end of Fallon's testimony that he starts to speak about Gallagher and the scope of Rohan's employment. In other respects, the scope of the employment is contradicted by Fallon's other testimony prior to getting to that, where he was asked how many harnesses did Low Allen have on the project site, and Fallon at 969 of the record says, well, we had 4 employees doing this job, and we had 4 harnesses therefore. So at all times, each of those couple of employees, including Rohan Clark, were expected to get onto the scaffolding, of course, and it's not true that Rohan Clark had no experience with scaffolding. His experience was in scaffolding, and he testified that he had a lot of experience in dismantling scaffolding, and that he also on numerous occasions asked Fallon to please provide a harness, and Fallon did not expect or provide a harness to anybody at the job, and neither did Empire. Now, Empire in its reply brief in this appeal finally concedes that it never claimed in its lead brief that adequate safety devices were provided. So they're admitting there were no adequate safety devices at all. So what we have is a classic height case, height risk case with an accident occurring with no provision of safety equipment. And the only statement is this hearsay, unreliable statement that on the day of the accident, for some reason out of the blue, somebody who's not available told the plaintiff not to go onto the scaffolding. But, this complaint was filed just a few months after the accident, and yet plaintiff's employer claims that he had no way of contacting or retaining any contact information for the out-of-court declarant Gallagher or for any other of the 3 co-workers. And yet Fallon would stop by and pick Gallagher up every day and be in touch with him, and took him to the hospital after the accident and totally knew how to get in touch with him. So, to now think that this unavailable witness's hearsay statement is in any respect reliable is not credible, I think. And this court in Carthen v. Sherman just last year, 169-416, 83rd 416, said the court is not required to shut its eyes to the patent falsity of a claim, even though usually, of course, self-contradictory testimony raises a question of fact. That's not always true, and it's not true in this case. In this case,
any questions? Any other questions for counsel?
Thank you.
Thank you, Mr. Golansky.
Thank you.
Do we hear from Penbrush next, or?
Yeah, I'm ready, Your Honor.
Go ahead.
May it please the court. This is Christopher Summer for Pen and Brush. My portion in relation to this appeal has to do with the court's granting of contractual indemnity to my client. The court ruled below that it was triggered by occurrence, and that is the correct decision. The clause in question is very broad. It states specifically that indemnity would arise from any act, comma, omission, comma, negligence, comma, potential claims and losses, etc. Empire is arguing that this clause requires a showing of negligence on the part of either itself or its subcontractor, Lock Allen. It's clear in that particular clause that negligence is one of many triggers in this case. It's any act. And that means that the accident itself was enough to trigger its indemnity obligation to my client. The two cases cited by Empire both have very different specific clauses that specifically require, quote, negligent act or omissions of the indemnitor. That's not the case with my clause.
Any questions for counsel? Thank you, Mr. Summer.
Thank you, Your Honor.
Good afternoon, judges. I'm Linda Stark, and I represent the third party, second third party, and the third party defendant respondent, Lock Allen Masonry. And I am asking this court most respectfully to affirm the decision of the court below. The more senior members of the bench have visited this issue on numerous occasions in their decisions in Purcell, Aaron Bury, and Sotoraba. And you're well aware of the standard. And my reason for arguing and also for having moved to strike the appellant's reply brief was because the appellant has taken things out of context and has used earlier reports, which this court has also held inappropriate in Lima. And if the court needs any citations, I have them here, has held inappropriate. In fact, in oral argument just now, counsel for Empire has referenced the October 30th, 2018 report of Dr. House Connect, which is in the record at 2154. However, the subsequent report from March 15th.
So the later reports show that the plaintiff is capable of being employed.
That is correct. Everywhere
and the
down
standard
the line,
is there has to be a total disability, right?
complete and total complete and total disability for employment, not temporary total disability. And almost every other doctor that the appellant has cited just doesn't comment. And these are not people that are novices at litigation. If they wanted to say that he was completely and totally disabled from unemployment, they would have said so. Dr. House Connect doesn't say it, and he's very familiar.
Stark, how about wasn't in 2015 there was an IME where Dr. Varma says he's neurologically totally disabled?
Yes, Your Honor. And then Dr. Varma saw him 2 years later. He said he was totally neurologically disabled within months after the accident because the accident occurred in 2015. It happened where he examined him within that year. Then he subsequently examined him approximately 2 years later. I believe the accident was March. He saw him in February of 2017, and he cleared him to go back to work. He was then seen by another workers' compensation, Dr. Jayarama, in 2018, and Dr. Jayarama cleared him to return to full duties, whereas Dr. Varma had said he can go back, but couldn't do any heavy lifting. So again, this is a perfect example, the court highlights a perfect example of where appellant has cited earlier reports in derogation of the later reports, and Justice Singh, you and Justice Friedman in Lima said that you couldn't do that, and that a report from 4 years earlier didn't establish a grave injury. That was your holding in that matter. And Dr. Brown never ever opined whatsoever as to whether or not this man had a capacity to work. And in this court's decision in Gomez versus VNG Electric, which is not part of this bench, this court held that there had to be objective clinical evidence of complete and total unemployment. And regardless of what counsel may have said in oral argument, the plaintiff's bill of particulars alleges that he was disabled, incapacitated, and most importantly, would have a diminution of earnings in the future, but not completely and totally unemployable in any capacity. So,
any other questions for counsel? Thank you. Thank you all.
thank you. Thank you, Your Honors, and have a wonderful, happy, and healthy Thanksgiving. May you all come through this pandemic glowing as you do today. I hope you and your families are all well. Thank you.
Thank you. Thank you. You too. This
All right.
concludes oral arguments for today. Court is adjourned.
Thank you.